issues with live streaming last week as well.
All good now. Chris has booted up, so
great.
Should be fine.
Thanks,
should be fine now. Thank you.
Great, thank you, Mr. Hardy. Apologies for cutting you off before you even spoke.
Don't worry at all. So David Hardy, partner at CMS, and I was present last week as advocate for the applicant. So on the team, principal representation today is going to come from David Bell, who's on. I can see on the call. He's there. We've also got representatives from the client, so that comes up as Rebecca Elliott. RE is the Roundel, and I suspect Kirsty is on the Kirsty Kelshaw, who was there last week as well. And then Keith Campbell, who is of counsel from CMS, works with me, is also on the call. So principally David. It may be that others interject, but that's us.
Thank you, Mr. Hardy. Morning to everyone. Mr. Armstrong for the council. Thank you.
Thank you, sir. My name is Douglas Armstrong. I'm King's Counsel, member of the Faculty of Advocates and representing Dumfries and Galloway Council. I'm instructed by Jennifer Jack, partner at Harper McLeod, and also from Harper McLeod today is Sandy Fowler. Our witness for today is Gillian Bailey, planning consultant.
Great, thank you, Mr. Armstrong. Good morning to you all. And Dr. Lloyd, I can see you on the screen.
I'll just unmute. Can you hear me okay?
I can, thank you.
Ashley Lloyd, I'm principally here as someone who's resident in the area, but I also have a technical interest in a lot of the calculations that underpin the proposal, specifically areas of wind stealing and the longer range cumulative effects. I've also had experience of taking a case against the UK government to the UN successfully in Geneva under the Aarhus Convention, and that related to the inability of the science to suitably capture measurements around impacts that were needed to manage systems properly. And I think I see similar echoes of that kind of generic problem in this particular application, and I'd like to speak to those later. Thank you.
Thanks, Dr. Lloyd. And Mr. McClymont.
Good morning, Mr. Warren.
Good morning. You're joining us today too. And did you make it home okay on Friday, Mr. McClymont? I hope so.
No, well,
Oh.
I don't want to take up this. Maybe we can discuss this at another time.
You've made it back eventually, though.
Basically, it was to sum it up very succinctly, it was a nightmare going back and also trying to get to Moffat. Thank you very much.
I'm sorry to hear that. Well, thanks for joining us today. Okay. Is everybody clear about what I've outlined for today, and does anybody have any questions or any other matters they'd like to raise before we get started? No? Okay, in which case we'll turn straight to the agenda, item 2, which is looking at national planning policy context. And I suppose where I'd like to get started is in terms of thinking about the overall tenor of policy, and whether the overarching principle of this development is deemed to be established and supported by the terms of the onshore wind policy statement and NPF4, or whether we still need to explore this in more detail. And I wonder, Mr. Bell, if I could come to you to get us started on that point, please, and then I'll open it up to others.
Thanks, sir. Yes, I think in answering that, I would say yes. I think the principle is established and supported. There are some key references in the onshore statement and in NPF4. What I think might be helpful if I go through each document, but if I pause after the onshore wind statement, just to get any further questions from you and to let others give a view. So if you're happy with that, I would start with the onshore wind statement. And it's worth having that to hand. It's set out in the hearing statement, but section 2.6, but I think I'll just highlight some key references. I think, firstly, what is helpful is at the very start, the ministerial statement on page 3 at the second last paragraph, where the Minister states, whilst other renewable technologies are starting to reach commercial maturity, continued deployment of onshore wind will be key to ensuring that 2030 targets are met. So 2030 is an important date, notwithstanding that the government's moved away from the 2030 emission reduction target. There's still, it's an important milestone on the way to net zero. Then Chapter 2 sets out what the government's ambitions are. And on page 5, there's 3 key points, I would say. At 1.1.2, the government's saying we must go further and faster than before, and that's in recognition of the substantial increase in demand for electricity as we move to a decarbonised society. 1.1.3, it says this will require a substantial increase in installed capacity. And 1.1.4, our aim is to maintain the supportive policy that will enable us to increase that deployment. And then over the page, at section 1.3, the government states it is vital to send a strong signal and to set a clear expectation on what we believe onshore wind capacity will contribute in the coming years. And then it sets out the 20 gigawatt minimum installed capacity, i.e. to be operational by 2030. And I think we'll come back to it, but this project has a grid connection date of 2027. So it can contribute, should it be consented, to that key date. I think what I would also bring your attention to section 3.6, which cross refers to NPF4, and it's entitled Landscape and Visual Amenity and NPF4, and that, of course, is the key issue in dispute at this inquiry, putting aside Estill-Muir for the moment. And what it says at 3.6.1 is that attaining 2030 will require taller and more efficient turbines. This will change the landscape, underlined. So, landscape change will happen, and we'll come on to it later. And the council has indicated where it anticipates there to be landscape change through its capacity study. Also, at 3.6.2, at the end of that paragraph, says stronger weight being afforded to the contribution of the development. Come to that term contribution when we look at NPF4 policy 11. And also the other relevant section, I would say, is chapter 5, which is about benefits of onshore wind. And within that section, 5.6 refers to tourism, and we covered this topic last week at the community session in quite a bit of detail. And one or two important points here at 5.6.5, the government's acknowledging that there can in some cases be discrete impacts. This is not the general rule. And it then goes on to talk about the significant opportunities to cultivate a people in place approach, and recognising the recreational opportunities. There's the Whiteley example, and this was covered again on Friday in terms of the opportunities to afford to recreation for all abilities and to make that assured and welcoming access. Lastly, I would say that the end of the document, it talks about, in the conclusion on page 49, that there needs to be the right balance struck, and that is entirely appropriate. And in the 3 bullet points on page 49, it says that government expects developers to actively engage with relevant authorities, agencies, and government. And that is exactly what the applicant has done. And maybe come on to it, but the engagement with Dumfries and Galloway Council and the council's expert landscape architect evident through the very lengthy response, shows that the applicant has done exactly what the government intends, is engagement with agencies on an application. The very last point I would say is at the top of page 49 says that deployment of onshore wind is mission critical for meeting our climate targets. And I note that Ms. Bailey in her evidence has underlined the scope of other technologies, and that's fine. The documents do say that, but the government has made it very clear that the key technology for attaining targets at the moment is onshore wind. Thank you.
Thanks, Mr. Bell. I'll open that up to others in just a moment. On that final point, Ms. Bailey. So I think I've got a note of in your statement. I think it's 4.2.12. You mentioned there the importance of other technologies, which Mr. Bell has recognised there. Does the importance of the other technologies take anything away from the support in the onshore wind policy statement in principle? Do you think?
Morning, sir.
Morning.
No, my view would be that it has to be read alongside that and alongside the wide support that there is for that range of renewable technologies. I don't, I agree with the points that Mr. Bell's making there in terms of those are very relevant paragraphs of the onshore wind planning statement, and that they do provide very strong support for onshore wind. But yes, it is obviously within the context of a broad range of other technologies and, of course, other pathways to decarbonisation in terms of reduction of demand or how we use energy demand, etc. So it's not the 2045 targets are not solely in relation to the generation of renewable energy technologies. So I think that's a relevant point to consider. If you like, I can talk about some other parts of the OWPS
Please.
that I was wanting to highlight.
Thank you.
So yes, absolutely. Noting all the points that Mr. Bell's made there are a few other paragraphs I would just like to highlight to you. And it's possibly useful, first of all, to look at the conclusions, and we'll work back from there. So if I can just go to the conclusions, which are on just find it. So yeah, page. Thank you. So the conclusion page and the third paragraph down states onshore wind will remain an essential part of our energy mix, climate change mitigation efforts, but we're also in a nature crisis. Onshore wind farms must strike the right balance in how we care for and use for our land, and we expect the onshore wind industry in Scotland to take up the following challenges. And the first point, I think, is it's a very relevant point in terms of showcasing, consider schemes that not only mitigate impact, but also improve and enhance our natural environment. And they give examples around identifying opportunities to secure positive outcomes for peatlands, forestry, and biodiversity. There are a number of other paragraphs in the hearing statement I think are useful to highlight. Going back to the ministerial forward, where he states that whilst it's imperative to meet our net zero targets, it's also vital that this ambition is delivered in a way that is fully aligned with and continues to enhance our rich natural heritage, native flora and fauna, and supports our actions to address the nature climate and the nature crisis. It then also just underlines the important role that statutory and environmental consultees have in the process, and particularly in paragraph 3.2.5, where it highlights that statutory environmental consultees, which obviously include Dumfries and Galloway Council, have an essential role in assessing that balance for onshore wind planning applications. And very much there's an interaction between the onshore wind planning statement and national planning framework for in highlighting that it is the concept of development in the right place. So notwithstanding there is that very strong support in principle for renewable energy technologies, and that does include onshore wind, it has to be looked at in the context of development in the right place. So I think those are two other paragraphs that it's important to highlight.
Thank you. And in terms of being guided on what is the right place, I assume we look to MPF4 and to the LDP principally to be guided on that point. Would you agree with that?
Yes, I'd agree with that.
In terms of the overview that Mr. Bell has given, would anybody else, Dr. Lloyd or Mr. McClimate, like to say anything at this point? Dr. Lloyd.
Thank you. Can you hear me okay?
Yes, thanks.
I think it's a very interesting. I really have read Ms. Bailey's report, and I think it has. I really appreciate her positioning this in terms of the right place, because whilst it is important to increase the amount of wind power we have, you'll note that we have to consider place in terms of its ability to generate wind. And this is one thing, of course, going back to the further submissions on wind stealing. But if you think about Hagshaw Hill, which is in the same area, is going through a repowering at the moment, the turbines that are being put in place actually capture 10 times as much energy as the ones they're replacing. So in fact, the site itself will be using less of the land to generate up to 5 times as much energy as it originally deployed. So the idea that we are simply able to increase the amount of onshore wind in Scotland by only using new land to expand the number of wind turbines is incorrect. We have to look very carefully at how we do things in the right place, because the right place is clearly where the infrastructure already exists, the ability to upgrade and renew exists. And that's very important, because at the moment, Scotland's carbon footprint per capita is the highest in the UK. It's the highest in the UK because of land use. And this is where I would ask Mr. Bell to explain to me what the environmental benefits under a carbon accounting scheme would be for Scotland coming from the Scoop Hill proposal. Because my understanding of the carbon accounting process, and I have done some work in carbon benchmarking and networking carbon markets, is that the only way that you can get a carbon benefit is if there's substitution. And the substitution that would occur for all the anticipated output from Scoop Hill will not be in Scotland. So since carbon accounting is Scotland-based, and Scotland is already sitting around 37th in the world per capita compared to a UK average of around 70th in the world, this is an issue we need to take very, very carefully. This is not necessarily the right place to get the substitution on a UK basis. It is not necessarily the right place to extract that efficiently. And by doing so, it would prohibit some of the natural renewal and upgrading of other adjacent wind farms. It's going to be so important to extract that 10, 20, 30 times more energy efficiency per turbine that renewal will give us. So there's a lot here that I think is important. And although the National Planning Framework is silent on some of the longer term wider area impacts like wind stealing, it has already been through the UK Secretary of State that where there are clear economic impacts on the other wind farms, such as wake loss, it's called in that particular case, then that can be part of a consideration at this stage in the public inquiry process, even though the regulations themselves are silent on an issue that they did not anticipate, but are generally worried about making sure that things work where they're put. If by putting them somewhere where they impact other wind farms and reduce the efficiency of overall energy extraction as a result, then that is something that can be considered in scope at this stage. At least that's the result of the discussions that have taken place at the end of last year, the UK building authorities.
Thank you, Dr. Lloyd. Mr. Bell, there's quite a bit in that. In terms of points around repowering and that as an opportunity, is the 20 gigawatt ambition capable of being met if we were to look at kind of existing sites and repowering opportunities, just in terms of that kind of scale of what's in the pipeline currently and what needs to be brought forward for that 20 gigawatt ambition to be met? I'd like your comments on that first, and then perhaps we could come back to the sort of wider point around kind of carbon calculators and the other factors that Dr. Lloyd outlined.
Yes. That's fine. No, I think one important point is grid capacity will be a constraint on repowering. There are also a number of life extensions being progressed rather than repowering. There are a small number that are in development phase, such as Novar, Cosi Meyer, Ben Glass, Crystal Rig, but they have not yet reached application stage. I think Mr. Lloyd's right. I think repowering has a role, but it won't at this stage be a substantial one. And the report I referenced in my hearing statement, the BVG report, sets out a scenario on how the 20 gigawatts could be attained. Repowering is in the mix, but the government expects new wind farms to come forward, and that will be the bulk of the new capacity. And the policy is clear. This public inquiry is not the forum to challenge the policy. We've been through what it sets out in the onshore wind statement. In terms of the carbon benefits, that is set out in the application documentation based on the government's carbon calculator, with an estimated over 700,000 tonnes per annum, based on a counterfactual position. And over the 40 years, about 29 million tonnes of carbon equivalent. And in terms of potential impact on other wind farms, the applicant does not accept that position. It's later on the agenda, and there's clearly a written submission that covers that topic. Thank you.
Thanks, Mr. Bell. Yeah, I will come back to this point in some more detail later today. But yeah, Dr. Lloyd, I can see your hand.
I'd just like to point out or respond to Mr. Bell that the counterfactual is based on a grid mix which doesn't apply in Scotland. I would just like a clear statement from him about whether he accepts that in a situation where Scotland in 2022 generated 3 times as much wind power as it was able to consume, exporting some £4 billion worth of energy, whether or not he can argue that there is going to be any fossil fuel substitution in Scotland on predicted output in 2027 plus on Scoop Hill.
Mr. Bell, would you like to respond to that?
Yeah, firstly, I'm not here to argue. I'm here to give an opinion as a chartered planner on the land use planning and policy matters here. I think the government's position is clear in that targets are not capped, and Scotland sits within a GB and UK energy market, and the position is not just Scotland. In the evidence put forward to the inquiry, there is a clear UK position, and we have made reference to, for example, the latest Climate Change Committee report, which shows that the UK is way off track. And I have drawn out a couple of quotations from that report that the CCC's view is that the UK needs to ramp up renewable deployment. Furthermore, in terms of export, Mr. Lloyd's correct. There is an export role for Scotland, and that is set out in the draft energy strategy and just transition plan for Scotland, which is before the inquiry referenced in the hearing statement. So that is what I would say in response. There's the UK context to understand and appreciate, and there's then Scotland's export ambitions, which are relevant. Thank you.
Thanks, Mr. Bell. Mr. McClymont, is there anything that you would like to say at this stage?
Yes, obviously I would like to say something, but if you could probably, the policy is set in stone, I assume, so you won't be able to deviate from the policy unless the government changes it. So, but I was kind of wondering on the first point, if you could summarise what Mr. Bell was actually putting forward, so that I would be able to comment.
So Mr. Bell has outlined what a document called the Onshore Wind Policy Statement says Dr. Lloyd has questioned some of the assumptions that the applicant has made in terms of carbon savings and kind of wider points around that. I can come back to you, Mr. McCormick, later on, so we've got plenty of opportunity to pick up any points that you would like to make. So just let me know when you'd like to come in. Would that be okay?
Yes, I don't want to hold up proceedings, but it was just on the point of net zero seems to be a lever that's always used to, push forward windmill applications. It's a sort of like a lever that's used to promote windmills. Thank you.
Thank you. Yeah, I don't think I'd be speaking out of turn to say that is a key driver behind the policy. Yeah, that's a fair point. Ms. Bailey, is there anything that you would like to say at this stage?
No, I don't really have much to add in terms of what Mr. Bell said there about the response to Mr. Lloyd's questions. A couple of points just again to highlight. I noticed from Mr. Bell's statement in, where is it, paragraph 2.6.11, table 2.3, he's undertaken a comparison of the status of onshore wind projects as they're set out in paragraph 1.1.5 of the onshore wind policy statement, and cross-reference that with the BVG report, which is document number CD 1627, and that's an annual report that's prepared on behalf of Scottish Renewables, just outlining the progress that's being made towards that. And obviously there is, as I say, there's a comparison there in terms of the different types or the different stages of projects.
Yes.
I think it's relevant to note that in the BVG report it also outlines that there is, when this one was done, which I think was 2023, there was a further 9.3 gig of projects that were now hang on, have I got that right? Sorry, just let me just check which one. It's the ones that are in development. Sorry, 7.66 gigs in development, and obviously that's not noted in the table. So it's just to highlight that point as well.
In development being
pre-planning, so ones that haven't got to any scoping or planning, and of course there are a lot of caveats with that, and the report does set that out in terms of we don't know how much of that will come towards in any planning or consenting process. So it does have to be treated with a degree of caution, but just to highlight that there is that additional figure to take into account in terms of that progress towards the targets.
Well, are you content that that's an accurate reflection of the BVG report?
Yes, I think that's fair. I mean, that will include schemes that are maybe in scoping and pre-application as well. So sometime will come forward in due course. Yes, that's correct.
Thank you, Dr. Lloyd.
Thank you. I just wanted to make the point that increasing grid capacity that Mr. Bell mentioned in relation to renewal applies even more so to new developments. So it's really important to recognise that grid capacity is a constraint, but it is a constraint for everyone. It's clearly ecologically more sound to reuse and repower existing grid connections where they exist, as in the case of the sort of repowering that's going on. And just to sort of make the point, remember that I introduced this question making the observation from the government figures that Scotland currently has the highest per capita emissions across the UK, and that the counterfactual is based on exporting energy from Scotland. It isn't based on using energy within Scotland, so this can only increase the carbon footprint per capita of Scotland. So that's a really difficult thing going forward. So we have to be really, really careful that we use these resources as efficiently as possible. I hopefully we'll come on to that later. But you can see that there is a disconnect between the way people use figures, and this is causing all kinds of problems, certainly in thinking more broadly. In the US at the moment, the situation has changed for renewable energy companies. You have to show now to both temporal matching of renewable energy against consumption and spatial matching. So if you export your energy over too long a distance, you're no longer getting credit for that because, of course, transmission costs themselves have a significant environmental impact. So an export focus, which is embedded in Mr. Bell's argument, isn't one that is seen, certainly today, as the most ecologically sound approach. We have to make sure that the sources and the destinations of the renewable energy are brought as close together as possible. And at the moment, that simply isn't the way things are working in the UK overall. But as we have seen, there has been a big unleashing of planning restrictions in England, and we expect to see that bring on a lot of energy very, very quickly, close to where that energy is actually required, requiring less updating of capacity. So there's a big mix occurring at the moment. Scotland is well ahead of the curve in terms of installation. Dumfries and Galloway is well ahead of the curve in terms of numbers of turbines. And so putting more here should just make things less efficient whilst monotonically increasing the carbon footprint. So, thank you.
Thanks, Dr. Lloyd. I certainly understand the point you're making. I think it's worth me noting now that in terms of my role, it's not my role to challenge UK or Scottish government policy. So we'll have to move forward with that understanding. In terms of transmission lines and grid capacity, we will come back to that, I think, under policy 11 of MPF4 and see what that says there and think about that in some more detail. Mr. Bell, thank you. You're on mute, Mr. Bell.
Sorry. Just to respond fairly briefly to Mr. Lloyd's points, I think his statement about grid capacity, it is a big issue. We certainly accept that, but it's not, he said it was for everyone. It's not for this scheme, just to be clear. There is a grid connection date of October 2027. So that needs to be noted. In terms of the carbon impact, I think Mr. Lloyd has got a point that there are real challenges on wider decarbonisation, certainly of heating and buildings, transport, industry as well. But that's also where the role of battery in this project is a benefit in terms of providing renewable generated electricity at the right times. Also, it's not for this project in terms of green hydrogen, but for example, I'm working at Whiteley, where there's a UK-funded green hydrogen facility going in after the wind farm has been operational for quite some time. That will help to decarbonise industry using the energy from the wind farm. Now, that's not happening here, but who's to say that may not happen in due course. But it's an example of how wind energy can be used for that wider decarbonisation. Lastly, Mr. Lloyd rightly said that the UK government has unleashed planning, I think, as he put it in England. That is correct. Interestingly, that is principally in relation to onshore wind, where the government has, amongst other things, set a target for the UK of 30 gigawatts by 2030 for onshore wind as a UK target. Now, given discussed planning pipeline, there's a healthy pipeline in Scotland, Ms. Bailey has rightly highlighted. There is not one in England because of the de facto ban that has been in for 10 years or so. And that's why the majority of the capacity for wind for that 2030 target will be Scotland and Wales, and probably more Scotland because of the real grid issues that Wales is facing. Thank you.
I was just going to add to that, sir, if I may, in relation to onshore wind in England. We're obviously heavily involved in all of that, and I think that there was an expectation that when the footnotes to the NPPF, which had the so-called de facto ban, were removed in July, that there was going to be a surge in activity. And that hasn't happened for a number of reasons. There aren't any, because there's been such a long period of inactivity, there aren't schemes on the stocks, and it can take 2 or 3 years of preparation and survey evidence for those to come forward. I think there are 2 schemes currently which are known about, and that's it. And then the other thing is that a lot of the constraints which were there in 2014, 15, and by that I mean size of the landscape, English landscape's different, some of the technical constraints like residential amenity, proximity to properties and aviation matters are still very evident. So just really endorsing what Mr. Bell has had to say, that from the outside it might seem as though there was going to be a sort of surge of onshore wind in England, but that actually is not the case.
Thanks, Mr. Hardy. I'd like to move us on to look at NPF4. You helpfully paused for us, Mr. Bell, there with the onshore wind policy statement. Would you like to give us the highlights of, for want of a better expression, of NPF4, Mr. Bell, and then we can open that up. I've got a few notes, but I'll let you guide us first, and then if I think you've missed anything critical, I'll pick them up myself.
Okay, thank you. I've got a copy before me. I think I've got the revised draft, which is in exactly the same form as the adopted version, but it may be the page numbers are just slightly out. But the first part of the NPF4, the National Planning Policy Document for Scotland, is the spatial principles and the spatial strategy. It's on my page 4. And I think an important starting point is to recognise that for the just transition and the transition to net zero, which is a spatial principle, it goes on to then reference sustainable places, and that's where relevant national development that we're talking about today falls within. And there's 18 national developments, and on that first page, it states that national developments will be a focus for delivery of the spatial strategy. That's just in the second last paragraph. And when you go to Annex B of NPF4, that's my page 99, it sets out that national developments are significant developments of national importance. And there is an acceptance that the benefits of national developments will be of national importance. When you look at National Development 3, which is what this development fall within, this is on my page 103, it sets out a summary of National Development 3, which includes generation capacity over 50 megawatts. And it sets out a statement of need. And there's a few points I would highlight just on this page. One is, the first paragraph states a large and rapid increase in electricity generation from renewable sources will be essential for Scotland to meet its net zero emission targets. And then the next paragraph talks about grid, but then further below that, under the subheading need, it states additional electricity generation from renewables and electricity transmission capacity of scale is fundamental. And here the development in terms of its wind component is over 8 times the minimum threshold for qualifying as national development. We'll maybe come back to that in terms of contribution of the development. I think also of note, just in terms of what Mr. Lloyd was referencing about carbon impact, and I appreciate Mr. Lloyd isn't dealing with this document necessarily day to day, as we as planners do, but there is a life cycle greenhouse gas emission assessment box, just the last paragraph for this national development. And it states that depending on the nature of projects taken forward, considering both direct and indirect effects, the life cycle greenhouse gas emissions assessment concludes this development will likely have an overall net positive impact on achieving national greenhouse gas emission reduction targets. So the government, in preparing NPF4, has undertaken a greenhouse gas assessment, and is of the view that these developments will likely be net contributors to carbon savings. Then beyond that, I would then look at the policies. I'm happy to pause there if you wish before we go into the development management side of the document, or should I continue?
Yes, but yeah, please, Mr. Bell. Let's pause there, because I think what we'll do is we'll pick up policies under item 3, which is kind of perhaps an artificial break, but we just so we keep track of where we are with proceedings. Ms. Bailey, is there anything you would like to add in terms of kind of MPF4's thrust in those overarching terms, and what the implications of this being a national development may be?
Yep. So I think firstly, it's important to remember that the relationship between energy and land use policy, and I have made some comments on that in section 2.2 of my statement, just to reiterate the point that land use and energy policy is very much interrelated, and we obviously know that the revised draft, which Mr. Bell just referred to there, of MPF4 was published in November 22, I think it was. The onshore wind planning statement was published in December of that year as well, so a few weeks later. So whilst it's clearly not specifically cross-referenced in MPF4, I think it's reasonable to assume that Scottish ministers were aware of its thrust and intention coming through as they were developing that. I think just in terms of the spatial strategy, I'd just point you towards page 7 of the document, which just highlights, and yeah, absolutely agree with all the points that Mr. Bell's made there in terms of what the spatial principles are. But on page, now is it page 7? Under the National Spatial Strategy for Sustainable Developments, it says that Scotland's future places will be net zero, nature positive places that are designed to reduce emissions and adapt to the impacts of climate change whilst protecting, recovering and restoring our environment. It does say meeting our climate ambition will require a rapid transformation across all sectors of our economy and society, but it goes on to say that this means ensuring the right development happens in the right place, and that is obviously a key aspect that that lends directly to the council's objection on this particular scheme. In terms of the national development status, yes, absolutely, it's as a national development, it benefits from support in principle through MPF4. Page 97 of MPF4 is, however, useful just to confirm how those are to be used in the context of MPF4. And it does say that the national developments are significant developments of national importance that will help to deliver the spatial strategy. They're intentionally high level and focus on key elements as the projects are at different stages. And obviously we know that in terms of renewable energy as a national development, there is no particular, it's not a project level development. It's a sector level national development. And it does say that national development status does not grant planning permission for the development, and all relevant consents are required. Their designation means that the principle of the development does not need to be agreed in later consenting processes. And certainly my view is that in relation to this particular scheme, you're not just considering the fact of the principle of the development in terms of the scale of the renewable energy, but you're having to look at it in the context of all of the other guidance that's in MPF4 and the local development plan as part of the development plan, and setting out and providing that guidance on where the right place is.
Thank you. Yeah, so that's an interesting point that you just raised. Then, sorry, so I'm just reading again. So their designation means that the principle of the development does not need to be agreed in later consenting processes. So in terms of the consideration of the principle of this case, I just want to make sure I understood that point correctly, Ms. Bailey. Can you so do you think that in this case the principle of development does need to be explored?
I think we'll probably come on to that in a bit more detail throughout the day, just as we discussed the terms of the council's objection, because I think there's a point to be made in terms of the way that the council considers it and whether they've considered it in principle or not. But certainly in terms of the way that it's expressed in MPF 4, it is clear that planning, that in principle, national developments are acceptable, but as I say, they do need to be read against all of the other policies which will help to establish whether the principle of a development which is, potentially anywhere across Scotland, where are the right places in Scotland for that development to go ahead.
Okay. So it's a case of, is it the correct site for the scheme being proposed, rather than the broader question of the kind of wider principle around wind farm development? Is that a fair?
Yes. I think the correct site, and obviously the council's clear concerns are also in relation to the scale of the development as well. So those are the issues that they're particularly concerned about.
I'm sorry if my microphone's picking up a lot of noise. I don't know if it is, but the bin lorry is right outside my window at this moment. So I'm sorry about that. So in terms of how the onshore wind policy statement and NPF 4 come together, I mean, Ms Bailey, you said there essentially, they won't have been written in a vacuum, and Scottish ministers will be fully aware of their overlap. Do you think they essentially kind of dovetail from each other, and they should be kind of read together as a whole in that way?
Yes, I do think they're both. I mean, I think if you were looking at this as a planning application, which obviously we're not, then the development plan has a different status. Sure. I think in the terms of a Section 36 consent application, they are both very relevant material considerations, and I do think that they dovetail quite nicely together. And certainly when you look at the part of the onshore wind planning statement, which talks particularly about the landscape and visual impacts, there's clear reference to the sort of the provisions that were coming through National Planning Framework for the draft that it was at that time, in terms of the policy situation that was evolving. So it's clear that the documents have been developed with overlap and can be read together. I don't think, as I say, although MPF 4 was adopted subsequent to the publication of the OWPS, I don't think the provisions of MPF 4, as it's been adopted, change what's in the OWPS.
Thank you. Mr. Bell. You're on mute again, Mr. Bell.
Brilliant, that's twice. That's not very good.
It's okay.
No, I'd agree with Ms Bailey about the interaction between the two. I think that's pretty accurate in my view. I think an important point as well about the onshore wind statement, we discussed it earlier, where it links to NPF 4. One thing we didn't mention was 365, where it refers to landscape sensitivity studies, the new term in place of capacity studies, where it talks about they're a tool to help guide development to less sensitive locations. And when we're talking about the right development in the right place, if the council's contention is this is not the right place and this is not the right development, then this has to tie in to the council's landscape architects' position in their response, where I think Janet Swales has said the majority of the scheme occupies a less sensitive landscape, LCT 19A. The only area in Dumfries and Galloway which has recognised scope for very large turbines. So, whilst I appreciate it's a starting point, there is a thread that runs through NPF 4, OWPS, and the Council's own guidance. NPF 4, will come on to Policy 11. It's a policy of support and facilitation if you are not in national parks or national scenic areas. Then the onshore wind statement, as its guidance, it points us to landscape sensitivity studies. The applicant has done that, is fully engaged, as it says in the OWPS, with agencies, and that guidance tells us this is where you should go within Dumfries and Galloway, which is the least sensitive area. Of course, there are details around any development coming forward that would need to be examined, and that was explored last week. But from a planning point of view, I think that's a useful way to take a perspective through the documents to the council level when you are establishing, where's the right place for a big development.
that might be a neat link in a moment into kind of item 3, and then we will then kind of pull that together in item 5 in terms of thinking about that overall planning balance. But before I move on, I want to make sure that everybody's had the opportunity to say what they wish to under this item. So I suppose, are there any opposing views on the kind of thrust of what energy and planning policy says? Dr. Lloyd.
Yes, thank you. I should preface this by saying that I'm not challenging the NPF or the planning guidelines. I'm simply making the point, as we have seen at the end of last year under the UK Planning Act EN3 in relation to renewable energy and wind farms in particular, that things that the planning guidelines are silent on does not mean that they are not encompassed by those planning guidelines. And I think that this is really extending what it means to put something in a particular place. And clearly, a lot of the discussions we've had are based on turbines of a much, much smaller scale. Remember, even large offshore turbines in the first generation were around 100, 120 meters tall. We're now talking about something that's 250 meters tall. So that means that when you talk about sensitivity, you're in a whole new spectrum. These are highly nonlinear devices with respect to the fact that as you get them larger, as they get taller, they get 3 times heavier. There are all sorts of things at play which are measured by cubic relationships in this particular case. And so, of course, sensitivity is nonlinear. So just because somewhere is identified as being a place doesn't mean that it is necessarily suitable for turbines of this scale. I would go further and say, when you start to hit that sort of scale, you are talking about things that have much, much longer range impacts, and we might come back to that. But if we just take what Mr. Bell said, that the UK target is 30 gigawatts, the Scottish target is 20, and that there is a pipeline in the UK or in England in particular, which is taking time, let's just iterate that forward a little bit. There is a large amount of capacity being unleashed in England. When that capacity comes on stream, it is absolutely ecologically the best argument to use the renewable energy which is closest to you. In which case, building developments today that are focusing on a promise of being able to deliver energy to Manchester, for example, which is a part of the Scottish Government planning horizon scanning. If you assume that, but by 2027, there is now a consented and in development wind farm which is closer, it will not be possible to sell into that particular market if you really are looking at cost of supply. And remember that England is already building pipelines to Morocco to bring in wind energy at far lower cost of production rates than any development in the UK meet. And so the market is moving in a direction which is going to make it very hard to sell into if it operates as a market in the favour of people. And if we build that capacity in Scotland under the current constraint system, if it cannot be sold to Manchester because Manchester has its own capability, we have to turn those turbines off, which means we end up paying electricity that is not captured, which is why constraint payments adding hundreds of pounds to current bills and could, under that scenario, add hundreds more. So unfortunately, we're looking at building an overhead and infrastructure which could be severely adverse for Scotland in the future, as well as, I say, necessarily adding to the carbon footprint. And just one other further point, I admit I'm not a town planner, I'm not familiar with the regulations at anywhere near the level that Mr. Bell and Ms. Bailey are familiar. But I do look at the calculations, and I do understand counterfactuals, and I have looked at the carbon calculator. And it is the case that this application is assuming substitution from oil-fired power stations, which, of course, as you know, don't exist in Scotland. So we have to think carefully about how some of these embedded assumptions are actually realistic even today, but certainly whether they're realistic in 2027. Thank you.
Thank you, Dr. Lloyd. I was going to pick it up later, but I wonder whether that's a point to pick up now in terms of the contribution this scheme would make and how that's assessed. Well, it's described, the output's described by the applicant as up to 432 megawatts. So, Mr. Bell, I assume that the 432 megawatts is if the scheme was operating at its absolute optimum capacity. Is that correct? And then could you tell us a little bit about the process of how the carbon calculator works?
Yes, that is the maximum installed capacity. In terms of the carbon calculator, there are various inputs to that, including an assumption on the load factor for the development, and it would also take into account the carbon costs in construction and procurement and so on, and it gives a calculation of when there would be a time period within which there would be a net positive impact from the development. I can't remember the exact figure in terms of carbon payback time as it's termed. Don't have that to hand, but I think it again gives a measure of carbon savings, and Lloyd's right, there is usually 2 or 3 ways in which that can be done as a counterfactual position. Grid mix is typical and more conservative. The biggest impact or benefit would be seen against replacement of fossil fuel generation, and I think it's really a tool for giving an indication, a calibration of the benefit. It's not that would be the exact benefit as a counterfactual position. It's to give the decision maker a feel for the likely benefit. So, in the planning sense, whether it's 500,000 tonnes per year or 700,000 tonnes per year, the point is it's generating renewable energy and there will be savings. How they outturn in due course, we don't exactly know, but that gives us a useful benchmark for the decision maker. But there are clearly other elements to that. There's the renewable generation, and the term in policy 11 is the contribution to renewable energy generation targets and greenhouse gas emission targets. So there's 2 aspects to that contribution.
In terms of the use of kind of grid mix, are applicants directed essentially to use grid mix as the appropriate kind of comparison or figure? How is that figure selected?
I'm not entirely sure of the specific direction on that, but it's certainly good practice to give range against the counterfactual scenarios. And grid mix is where you will have a range of technologies contributing to grid mix effectively. It may be gas, it may be renewable energy, and other fossil fuel derived generation. It's probably a simple way of putting it, is probably the more realistic scenario, rather than assuming it's all replacement of oil or coal generation. There are clearly no further coal generation in the UK. The last coal station was switched off this summer, and in Scotland there's no longer any fossil fuel generation.
So we are looking at a UK-wide grid mix essentially, rather than a kind of looking at Scotland in isolation.
That's correct.
On that particular point, I mean, I think we will probably come back to kind of benefits of the scheme as well later on. But on that particular point, is there anything else that anybody would like to say? No. Okay.
I would just
sorry. Yeah.
If I'm not making an appropriate comment, just stop me, Mr. Warren. But I'm thinking 432 megawatt. That's the capacity that it's able to generate but the downtime will be a significant factor in relation to output. For example, the downtime might cause to have to import more from other sources. So although it's 432 megawatt, it'll never achieve that in reality because of the downtime or the output, if you like. Now, this might not be an appropriate comment because I'm not sure, but if it's, you will stop me when I'm wrong. Thank you.
Thank you, Mr. McClymont. No, that was a very valid and fair point. And I think the applicant will recognise that the wind farm won't produce 432 megawatts consistently. That would be best case scenario. So, Dr. Lloyd.
Yes, I just wanted to, perhaps I should have raised this in the introduction. I wanted to be clear that I am not against renewable energy. I'm in fact helping to support a scheme which is twice as large as Scoop Hill, but is using a different renewable energy source, and that would be based in Scotland. And my role there is trying to make sure that the energy that is generated in Scotland is going directly into high value jobs within Scotland. So this would be used to provide base where a whole site is very, very low carbon, where we make sure we reuse all existing grid connections, because in fact, what is being missed from the grid infrastructure argument at the moment is we could use make much better use of the existing infrastructure that we have already. A lot of this hasn't been done. A lot of the assumptions that we need more capacity are questionable. Please be assured that I do understand the issues, I do understand the needs, and I do understand the opportunities, and I am very keen to see an expansion in renewable energy that actually provides real opportunities within Scotland, and those are possible. So I'm certainly not against that. Thank you.
Thank you, Dr. Lloyd. Mr. Hardy.
It would just be helpful, I think, so to understand from Dr. Lloyd what sort of project that is, just so we can try and contextualise some of the things he's saying.
Is that something you're able to share, Dr. Lloyd? I mean, it's not directly.
I think there are limits, but let me put it this way. I've been involved in building infrastructure between the first tri-continental high-performance computing links that allow us to share information, data, and steer very large computational activities across the world. This provides great opportunity for Scotland, which, as you know, certainly Edinburgh University is the only university in the world to have had 3 computers in the top 500 at the same time. There are significant opportunities in this arena. So if we're looking at computing, AI, and some of the algorithms that are important for business and economy in the future being supported locally, then making sure those are supported with significant amounts of renewable energy locally provides the ability to run rather important export capabilities for the expertise that's available across the UK via Scotland, using renewable energy to make sure that we build a sustainable future around that capability, which I think is going to be very, very important. So I'm very keen to have a platform to talk more about these opportunities. They are of a significant scale, and we need to think about them from the ground up. And my work has always been about thinking about how we build cables, how we build things up from the ground up to link the world rather better. And so I have a lot of expertise, history working on that, as I say, bringing continents together with this sort of capability. We can do that from Scotland. We have an immense array of capability here and expertise, but it needs to be coordinated. So we need real joined up thinking about what we're doing and how we're going to use that. And that's my concern.
It was actually just a much simpler question. So it was just to really understand, because the points were made about, look, there's a better alternative, or so we can contextualize that, just to understand what type of renewable technology that was. That was a simple question.
This particular one is solar. It has clearly a different footprint. There are no form of energy has zero potential negative impacts.
It was a relatively simple question, Doctor. It was just to
All right,
understand because I think the point you were making was that it was going to be double the capacity, and therefore that would, on the basis of that would be a sort of gigawatt of solar in Scotland. That is it. Just so we can understand what you're saying.
That's correct, and it's not for me to speak too much more about that project. But my input is looking at making sure that actually generates all of the things that's hoped for it in a very tangible and specific way, rather than general counterfactuals around things that might happen in the UK at some point in the future, which I think we need to get away from if we're going to make things work for the UK overall, generally, and specifically for Scotland. Thank you.
Yeah, thank you, Dr. Lloyd. Thank you, Mr. Hardy. Mr. Bell. Mr. Bell. Third time.
That'll be a fine the next time. We talked just earlier about capacity factor, and I think the average in the UK is below 30%. The additional information gives the estimated capacity factor for the development, and that will have been used in the carbon calculator. It's 45%, which is much higher than average. So that's positive for the scheme, in that it's a large project with a large capacity factor. I just wanted to give you that source. So it's paragraph 2.3.2, section 2 of the additional information that references that.
Thanks. Yeah, that's helpful. And in terms of when we talk about the load factor, essentially we're talking about the consistency and the quality of wind speed, I suppose, for want of a better expression. Do you have quality of wind speed? I'm not sure.
Well, the wind speeds have been measured, so it's a reliable, consistent wind that's contributed to that. Capacity factor is, I think Mr. McClyman is right. It's not running all the time at full capacity. It's a bit like a car. If you've got a car that can drive, top speed of 150 miles an hour, you don't drive it at that speed all the time in your day-to-day business. Your average speed might be 45 miles an hour. So for the wind farm, its average running will be around 45%.
Yeah.
That's not to say, it's idle all the time, but that is the capacity that it will run at.
Okay, that's helpful. Okay. I'd like to move us on to item 3. I wonder whether that's a good moment just to have a short comfort break. We've been going for a little while now, so I would suggest if we could take until 11:15. If we took till 11:30, so you've got time to have a drink and have a quick break, and we'll then move straight on to item 3, which is looking at the key development plan policy considerations. So just before we break, if you want to turn your camera off whilst we're having our break, please do. Please don't leave the call though, because that might cause us problems when we want to restart. Okay, I'll see you shortly. Thank you. Okay, welcome back, everyone. I'll just check everybody's back with us. Mr. Bell, I can see you. Mr. McClymont, are you back on the call?
Yes, Alexander's here. Yes, thank you.
Great. Okay. Thank you all. So looking at item 3, I'd like to start with looking at policy 11, please, which is energy. And I'm going to focus on part E in a moment. But before we get to part E, looking at part C, which says development proposals will only be supported where they maximise net economic impact. It goes on to say a little bit more about what that might include. Now, this point around kind of what maximised means, I know has been subject to kind of careful consideration by reporters and Scottish ministers and no doubt councils. And I'd be interested to hear what decisions to date kind of tell us about how to apply 11C, and then moving on from that, whether this proposal can be considered to have satisfied this part of the policy. So, Mr. Bell, can I come to you first, please?
Thank you. Yes, unfortunately, there's no guidance on this policy, and I think most people in practice struggled a bit when this first came out because of the wording about maximisation of net economic impact. But I think there's maybe 2 points to make. First one is that there is a very strong policy drive from government to maximise the benefits of renewable energy development for the economy. And that's most recently expressed within the Green Industrial Strategy, which is before the inquiry. I'm just trying to get the reference to that, which, bear with me, at the end of my chapter 2. And it follows on from the onshore wind sector deal, which is about maximising benefits of to the economy. So it's CD 016.020, the Green Infrastructure Strategy. And I've set out some quotations from that in section 2.9 of my hearing statement. I won't go through those. But I think that's the first point. The second point was I've looked at all the Scottish Ministers' decisions since NPS4 came into force in February 2023, and the Scottish Ministers make the point in all of the decisions that the development will have positive socioeconomic impacts, and they rely upon the reporting of construction and operational employment and the GVA figures that are usually within an environmental report, and they are in the EIA report for this development. They don't go beyond that, and they don't seek to impose conditions or any additional requirements beyond that recognition of benefits as reported. What I would say is that in my chapter 3, I've sought to summarise the benefits, and there's an economic benefit section. One of the additional measures that the applicant is proposing is thereby Scottish policy during the development, construction, operational phases, and that's been implemented by them before, and that's an additional commitment which you don't often see within nations. So my view would be, notwithstanding there isn't guidance, we can look at the Scottish Minister's position, how they've handled it, and indeed reporters. And the information is there for you to take into account for this development. In my view, that would satisfy that policy provision.
Yes, Mr. Bell. Ms. Bailey, do you agree with Mr. Bell both in terms of the application of 11C and also then I'd welcome your views on the extent to which you consider this application satisfies this part of the policy.
Okay. Yeah, so in broad terms, yes, I agree with what Mr. Bell's saying in terms of the context, and that there's no particular guidance for determining authorities in terms of how to interpret this particular policy. I guess the one of the points that that comes to my mind when you look at this particular part of it is in terms of that use of maximising net economic impact, and I think it's important to remember that that's not necessarily in terms of the larger a development, the greater the impact, but it's in terms of looking at what is the impact that's proportionate to the scale of the development that's being sought, if you understand what I mean. Because clearly, yes, you will, by default, you would anticipate have a greater economic impacts from larger schemes. So I think you have to look at it on a case-by-case basis and look at whether that particular scheme has the developer, the applicant, done what they can do in terms of maximising that net economic impact. It's not an area that the council has any particular concern with, and certainly that wasn't, that wasn't raised by the committee members. And I do note in paragraph 4.48 of the committee report, which is CD 1723, the case officer had summarised where they'd got to with the economic and the socio-economic and environmental benefits that would occur. So there's no objection in terms of the council's perspective that this part of the policy isn't satisfied.
Okay, that's helpful. Dr. Lloyd or Mr. McClymont, have you got anything to add at this stage? Dr. Lloyd.
Yeah, I think if we start from where we sort of ended off, it's clear that the environmental benefits are being argued on a UK-wide basis and will occur elsewhere. The economic benefits that attend any large infrastructure development, of course, have real benefits in terms of employment around the construction phase. We have to separate construction phase from long-term benefits. And even during the construction phase, I'm still not sure what the Bi-Scottish policy is allowed to do under law when it comes to competitive tendering. I would like to have that explained, because I think this is a wonderful aspiration, but it has it's an aspiration that has failed in many times previously, and it's hard for me to see on what legal basis going forward the developer can actually, the applicant rather, can actually ensure that they are going to be preferring in some economically advantageous way local suppliers or Scottish suppliers. Thank you.
Thanks, Dr. Lloyd. Mr. Bell, do you know the answer to that question? I appreciate it's not strictly a planning point, or Mr. Hardy.
Well, just to understand, it seemed to be a sort of public procurement point that was being raised. Of course, that's not the situation you have with a private developer. So I'm not quite sure.
Okay, so that's essentially the position is as a private developer, you can select whoever you wish, and there are no kind of rules binding you.
Yeah, it's just a bad point.
Thanks. No, that answers the question. Thanks. So in terms of policy 11E, I think this is where this is going to take a bit more time. So we have 13 kind of points there to look at. Ms. Bailey, just a point of clarification, really, or just to get your kind of take on this. And it's a minor point in one sense, but I think it's also kind of critical to how we kind of look at these points. I think you've referred to these as criteria, and my question is: are they criteria, or are they considerations, or are they a mix of the two? So I suppose if the criteria, there's something you would expect to have to be kind of satisfied in some way, whereas if they're considerations, that's kind of a slightly less tangible point which you have to put in the mix as part of an overall balancing exercise, if that makes sense.
Yeah, okay. from a planner's perspective, I would have described them as criteria, and I have set out in my statements that I think you are looking at all of these together. Yes, there is clearly a part of that wider balancing mix that needs to be taken into account, and not just looking at this policy, but looking at how it sits in relation to all of the other policies in the local development plan. But I would describe them as criteria that the application should be assessed against, in a similar sort of way as the local development plans, their policies, and the RE1 and RE2, IN1 and IN2 criteria set out the issues that the applications to be assessed against.
Okay, I don't want to make a point or make something out of nothing, so that's helpful clarification. Mr. Bell, I don't know if you've got any view on that.
Yep, I'd say I did pick up on what Ms. Bailey said, our paragraph 5.3.14. She states that if one criteria is not met, a development would not be consistent with the policy. And I just don't agree with that approach. I think you need to read the policy as a whole. And when you get to the end of the policy, it states that in considering the impact, significant weight will be placed on the contribution of the proposal. So, it's the same with, when I deal with other long criteria list policies. If there's an issue with one, that goes in the balance. It doesn't mean that that's it. That's the end of it. You're contrary to the policy. I think that wouldn't be the right approach. Thank you.
Ms. Bailey, I assume you take a different view on the basis of what you've outlined.
Yeah, I think I appreciate the point that Mr. Bell's making there, and absolutely it's a case of balancing all the different factors and criteria of the policy together and reaching a view in terms of the wider policy. And obviously it's for the decision maker to consider to what extent they give weight to each of those different criteria. And I think the point that I'm making is that you could not, and perhaps I'll clarify, you could not say that it's fully compliant with the policy if it does not meet all of those criteria, and that would then be where you would be considering how you would make that judgment as to whether it's broadly compatible with the policy or not.
Yeah, I understand both perspectives on that point. I don't think I need to press any further on that. Okay, so I think the first point. So where I would like to focus is probably 11E2, which is around landscape and visual impacts. You won't be surprised to hear after last week's discussions. Because in the landscape and visual inquiry, we gave some attention to what localized may mean, and I'd like to explore this further this morning, and also the matter of kind of what mitigation means in this policy context. So I listened carefully to what Mr. Welsh had to say about his interpretation of localised, and essentially that it needs to be kind of calibrated to the sort of scale of the scheme that we're talking about. And there are some similarities there with what you just said, Ms. Bailey, in terms of calibrating the sort of net economic impact relative to the scale of the proposal that we're considering. I'd like your views on that approach, and whether or not localized should be interpreted in that way, as to whether or not it's a something that has to be adjusted relative to the scheme, or whether it's a more, I suppose, fixed or absolute kind of concept for any given location, where you could define what localized may or may not mean, and also the factors that you take into account, recognizing I think there's agreement that it's not just a geographical point that determines what localized looks like. There's quite a lot to think about there. Dr. Lloyd, I can see your hand.
So sorry, it was really in relation, just before we left the last one. There were three parts to my question. I just wanted to separate out the construction phase economic benefits from the long-term jobs that are created as a result of the scheme. And I think it would be nice just to see what the long-term implications would be for the community around job creation, because experience to the present point suggests that where these things are put out to tender, and albeit that you have a right to buy at a disadvantageous rate if you so choose, most organizations will operate these things on a minimum cost basis. And so the contracts usually go to larger organizations that are distributed around the UK. The jobs don't generally come to the area. The people are maybe living there temporarily in tourist accommodation, but they're not actually embedded in the community, and the spillover benefits accordingly are much more limited. So a little bit on the long-term jobs, I think, would be really helpful here.
Thanks, Dr. Lloyd. I mean, so in terms of the, I suppose, the kind of employment profile of the proposal, Mr. Bell, where would you direct us? I know I've read it. Whether I can lay my hand on it immediately is a different question.
Yes, in my hearing statement, page 32, there is a summary of the operations and maintenance phase, where there is reference to the creation of jobs within Dumfries and Galloway and wider afield in Scotland. So 52 jobs in Dumfries and Galloway and an estimated 84 in wider Scotland from the spending that would take place within the supply chain for operations and maintenance. Now, some of that will be local, whether that's a fencing contractor or track maintenance and so on, or other habitat management activity, or whether that's a supply chain further afield. And there clearly will be less than the construction phase, but there are still important jobs there and economic impacts to take into account in that phase. Thank you.
Thanks, Mr. Bell. So in terms of, I mean, we often hear, I think somebody mentioned it last week, you say we see these headline kind of numbers sometimes, and in practice people get the sense that, well, actually there only appears to be a couple of people working on this kind of full time, and we don't see this job creation that was promised. But so just reading kind of carefully there on page 32 of your hearing statement. So it says, during the operations and maintenance phase, the proposed development is expected to support the following each year. And then you've got 52 jobs in Dumfries and Galloway, 84 in Scotland. So that support, I suppose that's the key word there. It's not necessarily creating the jobs. Is that right? It's sustaining existing jobs.
Well, I think that's where the socioeconomic assessment needs to be examined, where all the assumptions are set out, and there will be reference to direct, indirect, and induced employment effects, which give a number at the end of that. And I think especially when you've got a large-scale development. So, for example, another large-scale scheme is Crystal Rig in the Scottish Borders in East Lothian, where I've been on that site. There is constantly sequential maintenance of turbines, where you've got engineering crews there servicing or doing other activity. Similarly, up another large-scale scheme, Rothes, up in Murray. I've been up there and met the locally embedded maintenance team that are living in the community in Murray. You see them with their vans going around, and again, that's important to recognise that where you've got the larger projects, that's where there'll be cost efficiencies in having a local presence as well. And that's evident with Crystal Rig and with Rothes, and there's no reason why that shouldn't, or here, together with a deeper impact on the supply chain locally. It would make sense for local contractors to be able to supply on a consistent basis, especially when you've got a larger scale scheme. There's larger scale contracts that could potentially be realised.
Just going to add the document reference, so it's chapter 5 of the additional information.
Great.
So that's where that is set out.
Thank you. Lovely. Thanks for that. That's helpful. Yeah, sorry, Dr. Lloyd, for jumping ahead too eagerly there. Thanks for bringing me back there. So yes, on the policy 11E point and part 2 of policy 11E, and this question of what localized means, I give you my sort of rambling thoughts to kind of trigger some discussion on this point. But if I could come to you first, Ms. Bailey, in terms of your kind of interpretation of what localized should look like in this policy context, that would be helpful, please.
Yep, certainly. Sorry, can I just clarify? I'm having a couple of slight intermittent network quality issues.
How are you?
So it was coming on and off. So if I disappear, just bear with me.
Did you hear everything okay?
I think it was just fractional, just a couple of times there. So I think I caught everything, but
Thanks for the warning there. Yeah, we'll keep watching out.
In case I freeze. So yes, just in terms of the issue of localised, and I've obviously covered this matter in the hearing statement, and particularly I think from paragraphs 5.3.19 onwards, and certainly in terms of the scale of a scheme, that is, I think, it absolutely has to be a factor in terms of whether the impact of that are going to be localised or not. I don't think it is determinant of whether the impacts are localised. You've got to look at the scheme on its own merits, and looking at the landscape context and the situation that it sits in. I've obviously mentioned in the statement that it's not necessarily just geographical interests which should be taken into account, and obviously we are working in a bit of a guidance vacuum, if you like, on this, and that there is no particular guidance for planners or other people working in this sphere in terms of how to actually determine what is meant by localised. But yes, I think when you look at the wider concepts around the sort of the value of place, and you look at the concepts around where not just where a development is going to be viewed from, but how a person might experience it and where those people are coming from. I think those are all very important factors to be taken into account, and having regard to some of the very sensitive viewpoints that I think have already been highlighted last week. The sort of the scenic route coming down towards Moffat. You've got the M74, which is a major strategic route into and out of Scotland. There are a number of areas which are going to mean that the number of people that would be experiencing and viewing the wind farm might be far greater in this particular context than they might be in a more remote area. So I think that's absolutely a factor to be taken into account. But I wouldn't necessarily say it is just by virtue of the factor of the scale of the development, but it has to take into account what is all the different aspects around the impact on landscape character, the impact on visual amenity, but also very much concerning who's going to be impacted by that as well, and what are the impacts on people as much as on place.
Thank you. Mr. Bell.
Thank you.
Thank you.
I think that's a fair summary of it. I don't have much disagreement with what Ms. Bailey said. I think scale is an important factor, and I think Mr. Welsh had said that it's very much linked to scale. We don't have guidance on this topic as well, but there is some helpful calibration from some other decisions. One relevant one is a canny. I don't have it at my fingertips, and it may be before the inquiry. It was a Section 36 decision, canny, ACHANY, where the ministers and Nature Scott said for that scheme, the localised effects extended out to 10 to 12.5 kilometres. Now, that was a different scale of development. It was 149.9 metres So, I think, as Ms. Bailey says, it's a matter of looking at each individual scheme in terms of heights and the geography around it. And so I think Mr. Welsh's position was that landscape character impacts significant out to about 11.5, visual to 18, and he made a cautious point about out to 20 kilometres at one place. So when you compare that against Annie, it's not too different when you consider the increase in height that you've got here. I also agree with Ms. Bailey in terms of what is affected. I think that's important in terms of the receptors. And there is a previous decision where the reporter had said that the automatic default of it generally acceptable if your impacts are localized may not apply if you have a very sensitive receptor in close proximity. That makes sense if you've got a particular impact. That may not be acceptable. But I think that's where in a given scheme you need to look at what is affected. And I think an important point that Mr. Welsh set in was that although some of the ZTV coverage looks reasonably extensive, a lot of that, a large proportion, is forestry. And also when you look at the screened ZTV, there is certainly fragmented visibility and intermittent visibility. So I think all that would need to be taken into account.
Thank you. Ms. Bailey.
Unmute myself and lower my hand. Yeah, so there was just one other point that I had meant to mention and I forgot to mention, which was just in relation to the four-side decision, which might also be a useful pointer towards you just in terms of looking at some of the aspects that were considered there around localised. And particularly, so this is document reference CD 1827 and paragraph 9.2.1 of the reporter's report there. And in that scheme, obviously, it's a different scheme to the one that's been presented here. It talks about you need to look at more than distance in terms of determining localised impacts. And they considered in that case that the following significant landscape and visual impacts would not be localised, and they talk about extended views from within and across the valley from elevated locations. It talks about significant adverse effects along the valley and also for extended periods along the A7 borders historic route, and noting that those views would not be contained to a local area or just to local residents, but also would be experienced by visitors and travellers exploring the area and using these routes, and also for recreational users who access the hills and the surrounding countryside, etc. So I think those paragraphs, I would certainly suggest it's useful to look at those in the context of considering some of the factors that should be taken into account in determining localised or not.
Yeah, thank you. Lloyd.
I think that in the community session on Friday, you had many eloquent expressions of how people feel about their place. And I think that it goes to the dynamics of all these things that are happening, the excitement around things as abstract as the Merlin Trail, which you saw generated quite a lot of discussion about whether this was true or not. People got engaged in the history, and that made their sense of space and place much keener for those in the community. There were lots of activities going on, lots of investment in dark skies, golden eagles, all to do with place. And I think that if you damage part of that, the contagion effect would be quite significant. It takes a lot of enthusiasm out of proceeding with lots of other activities. So I think there's a high degree of sensitivity there around the dynamics of the social cohesiveness in Moffat and the surrounding areas. I'd also like to, and I hope that's all read because, as I say, other people have spoken to that far more eloquently than I can and have brought together 50, 60, 70 years of living in Moffat. But one thing I would like to point out is this continued reference to forested areas being somehow degraded. Now, I live inside the largest forest in Britain, so there's a lot of Sitka spruce around here. Sitka spruce grows to maybe 50 meters before it's harvested. These turbines are 250 meters to tip. So the relevance of comparing forestry with something that is 5 times larger is, I think, limited in this case. One will dominate the other, whether or not those trees are there or they are patterned in some way, given land use that still involves hill farms, is of a different scale to the proposed development. So these are way above anything to do with treetops. They will be visible, of course, even within the forest, because you don't need much space to be able to get a subtended angle that is large enough to see something that is 5 times larger than a tree. The screening effect really isn't there when you're in the forest, and when you're looking down on the forest, they're still going to dominate that view. So this scale argument is, I think, really important at 250 meters. It really is nowhere near comparable with the sort of existing of use within clearings within the existing, for example, Forest of A, where these turbines are much smaller presently than the ones being proposed. So we really can't get a clear view of what this is going to look like. But I think what people who do understand a little bit more about visual amenity have said very clearly is the impact is going to be severely adverse.
Thanks, Dr. Lloyd. Yeah, I mean, I've got to be careful to not stray back into landscape and visual inquiry territory here. I think the point in terms of kind of considering localized effects and thinking about tree cover, I take Mr. Bell's point there around the evidence around the sort of screen zone of theoretical visibility. So that takes into account kind of existing tree cover and kind of thinking about the effects of that, and whether 15 meters assumed height, for example, makes a difference will depend on where you happen to be stood. Mr. Hardy, I can see your camera has come on. Yes. Would you like to say anything?
Just very quickly, in relation to that height point, and it may be that we come back to this in connection with local development plan policies. I just want to raise the updated draft landscape sensitivity study, because of course that deals with turbines up to 250 meters in height. So the points that Dr. Lloyd makes have been looked at, and actually the council has had an opportunity to say what it wants, and in that draft has considered that the lee sensitivity is in the area in the host LCT. So it is those people who do know what they're talking about, and by that I mean the professionals and the council have come back with that in the draft.
Thank you, Mr. Hardy. I'll come back to you in just a moment, Dr. Lloyd. So what I don't want this to become is a reconsideration of kind of like the landscape and visual evidence that we've already had. So I'm going to be very kind of clear on that point now, and I'm not going to let us stray back into that. The point around the sort of draft sensitivity study is relevant insofar as it is intended to be a part of the development plan ultimately once it's adopted. So it's got that relevance in this session here. With that caveat, Dr. Lloyd, come back to you.
It is really to say that is a draft that, if you look at just a simple comparison of the draft and the previous iterations, the inheritance of the same structures but a rebasing of what large means is essentially what seems to have happened in the first instance. So I don't think this draft represents an appropriate consideration of a real change in scale. It simply said what was large before is now very large, and we just simply move those categories across. So it's a draft, and I wouldn't invest too much in saying that, or I wouldn't imply from that these things have necessarily been considered to the degree that Mr. Hardy suggests.
So all I would say, I'm not going to reach a view on it here, but in terms of its kind of status, yeah, recognise it's a draft, it's subject to change, and what it ultimately says will be within the sort of council's gift. So we will, given the timescales that have been outlined by Mr. Armstrong last week in terms of what's anticipated, it's possible, if not probable, that I'll see the final version of that before reporting to ministers, or certainly ministers will be aware of it before they make their final determination. So I think we can leave that there for now. In terms of, okay, so I think we can move on from the localised point. I understand. I don't think there's actually a great deal between certainly Mr. Bell and Ms. Bailey on this point. It's largely kind of, it's a case of how I ultimately interpret these different factors and in the context of this scheme. The second part of E2, just get that back in front of me again. Yeah, so this relates to whether appropriate design mitigation has been applied. And I'd like your views on whether such sort of mitigation should be identifiable kind of components of a final scheme, or whether pulling back from a larger scheme with more widespread significant effects is itself mitigation. There was some discussion, interesting points made last week about this, about whether essentially this encourages applicants to put a larger scheme forward than they ultimately intend or expect to be able to gain consent for. I think that was raised by Mr. Barker and Mr. Mundell. So that I'd like to kind of understand whether or not not saying that's a factor here, but whether the policy, I suppose, encourages that type of practice. But with all those thoughts in mind, yeah. But particularly on the point around whether mitigation is it mitigation by design, and what does that look like in practice? I suppose I'd like to focus on that mainly. Can I come to you first, Mr. Bell?
Thank you. I would say at the start, there's always been engagement with consultees for developments that raises issues, and then developments are adapted to get a settled position on a scheme that's acceptable. And I think in terms of mitigation by design, certainly for a wind farm, the mitigation is not going to be bunding or planting on the edges of a scheme. It's going to fundamentally be amendments to the infrastructure layout, principally by way of turbine locations or presence. And in this scheme, there's clearly been a number of iterations, removal of turbines, and I think it's helpful to have a look at what the Council's landscape architect said. I mean, just taking it briefly on page 7 of the landscape architect's response, there's a very helpful statement, I think, where it states that it can be argued to have gone a long way to addressing the most impactful siting and design issues through design reviews. And also for most visual receptors, poor design issues have been addressed. And as I said before, the developers have participated in negotiations on the proposals and have addressed the most severe significant effects. That's all from the Council's landscape architect, and that goes back to that engagement point, and taking into account issues that have been raised, concerns, and adapting a scheme, and preparing the associated environmental information to support that. So I would say that demonstrates that there has been appropriate design mitigation in line with what the policy here is envisaging.
So in terms of that point around, are we seeing schemes over proposed essentially to be able to show that design mitigation? Say, for example, so I've got the scheme in front of me that's 60 turbines. I'm not considering the 75 turbine scheme. So there's an interesting question there about, well, am I concerned with the background narrative in terms of how it became 60 turbines from 75 turbines, or is there an expectation that I should be able to point to, actually looking at that 60 turbine scheme in isolation, these are the factors which I can point to which show, I suppose, mitigation against the most significant effects that may have otherwise arisen? It's a tricky point, isn't it?
I would say you need to deal with the scheme that's before you, and the application has been amended to what it now stands at. But the history of the application, I would say, is a relevant consideration for you to take into account. because the reasoning set out by the council's landscape architect is based upon the journey that the application has had and how the impacts have been addressed. Because the policy 11E says project design and mitigation will demonstrate how the following impacts are addressed. So it's not criteria that need to be passed or failed. It's, how have these issues been addressed? And Mr. Welsh has set out that from his perspective. Council's landscape architect has set that out from their perspective, and that reasoning, I think, is helpful for you in understanding how the council's architect put it. The most severe impacts have been addressed through these design reviews. I think that's entirely relevant for you to take into account when looking at the role of design mitigation, which for a wind farm, really principally is the position and number of turbines.
Thanks. Okay,
Thank you. Yeah, there's probably a number of points just to clarify in that aspect. And I would say, yeah, it's absolutely acknowledged that there has been what seems to be quite a lengthy period of discussions between the applicants and between the council's case officer and the landscape architect during the process of the application prior to it getting to the council's committee for a decision. And I think that's an important point to remember, that just in terms of what the committee saw before it was also the 60 turbine scheme. They had not seen the 75 turbine scheme. So they were basically they were basing their decision on what was before them in that sense as well. Just looking at MPF 4 and the way that Part E is described, and it talks about project design and mitigation demonstrating how the following impacts are addressed, and then it obviously goes on to all of those criteria or considerations, whichever you consider them to be. In my view, that's a key component prior to it getting to the consultees as well. I do note that from the design and access statement that was provided for the additional information, that there was a series of design principles that influenced the revised scheme. I haven't seen that there's anything similar that was done for the original scheme, so it's not clear to me in terms of that, those overarching landscape design principles, what was originally accommodated or what was originally considered. And I think that is important to bear in mind, and that mitigation isn't just about that element of chipping away, if you like, at the scheme once you get to that process of discussing it with the consultees, but you need to be coming at it from a starting point of what's all the information that's out there prior to that stage in terms of all the relevant design guidance. Obviously the council's landscape capacity study is a key consideration in helping that, and I'm fully aware that that the applicants did look at that, but they didn't necessarily provide a sort of a series of key design principles. But it seems to be more that has been as a process of those ongoing discussions to therefore get to the 60 turbine scheme, whereas I would certainly view it as something that needs to be considered much earlier, and not just as a consequence of consultees expressing their concerns. And obviously I note that Mr. Bell has highlighted, and rightfully highlighted, that the landscape officer did ultimately come to a conclusion that she wasn't objecting to the application. She did state in her response to the case officer that purely on landscape and visual grounds it could still merit an objection, but she acknowledged that they had addressed a number of the concerns. There were still, and I'm sure you probably heard evidence on this last week, there were still a number of outstanding concerns that she had, but they clearly got to a position that the applicant had also come back and said we're not doing any further, and she made a view on that basis. But as I say, I certainly think that you need to be looking at it much more from the outset, rather than looking at it as that iterative process once the scheme has, once the initial scheme's been submitted.
Thank you. Dr. Lloyd or Mr. McClyman, is there anything you would like to add? Dr. Lloyd.
Yes, thank you. I appreciate with due deference to everyone's experience of the process, but it seems to me there are different kinds of impacts we're talking about here. There are the impacts that relate to measurable changes. There are impacts that might have been measured but haven't been because they don't currently form part of consideration on the planning framework. And there's also the risks of impacts, and these seem to me to be in different categories. If we just think about impacts that have been measured and impacts that are established as risks, mitigation seems to me to be something that is problematic in this case, because as we've seen on Friday, when you talk about things like planning regulations for battery electronic storage systems, these guidelines are sort of being derogated to someone else's concern rather than part of the current planning decision. So it becomes possible, therefore, to approve something at this stage for which the case around safety, fire safety, has not yet been properly explored. And I find that to be difficult. I'm not sure how comfortable you are with that process, but I would like to see the conversation around mitigation clearly define what sort of impact or risk of impact is being mitigated and where that boundary it extends to, because I think it's fair to recognize that there are some risks and some impacts that are not being counted in the current process.
Thanks, Dr. Lloyd. Yeah, I mean, so in terms of policy 11E2, the point around mitigation there is limited to kind of like the landscape and visual effects point. But that said, policy 11 does have other criteria or considerations that need to be brought into consideration. So I don't know, Mr. Bell, if you'd like to make any comment on any of those wider provisions now in terms of the some of the wider concerns that we touched on last week as well. I don't know whether we can pick any individual ones out, which would be helpful, or Mr. Hardy.
It rather depends on what you what you need assistance on. So do you mean specifically BESS? Because that we put the position across as we saw it on Friday. So I'm not sure we can happily go over that again. But is there anything, or are there any other issues that you want us to deal with?
Thanks. Yeah. What I'll do actually is if we hold that thought, and I'll come back to it in terms of item 4, in terms of policy gaps, and just thinking, okay, we can just think there. Okay, what does policy say, but what does policy not say, and what are the implications of that?
I see that BESS is one of those things, isn't it? Fire safety is one of those things that is in that list. So if you're happy to do that, we'll come back to them.
Yeah, thank you, Dr. Lloyd. I haven't lost the point. Okay, I will. I'm forgetting my own agenda here, so I need to just come back to that point. I think just for the sake of the sort of structure of the discussion. But yes, we will come back to it. So, okay. So, Mr. Bell, just to give you an opportunity to respond to Ms. Bailey's points, if you wish to, but I'm happy to leave that there if you are.
Yeah, I was just briefly, I think in terms of the iterations of the development, I think this is, I would say, a good example of a responsive developer. You know, at the outset on this project, at scoping stage, there was very little feedback from the council. And of course, there's been major resourcing issues. We understand that. But it's certainly good practice to engage with consultees and amend a scheme. And it's preferable to do that rather than take what could be deemed an unacceptable scheme through to public inquiry if that is going to be the end result. So I would say this is a good exemplar of proper engagement with the Council of Landscape Architects. And it's not a 2-page response from the Council of Landscape Architects. It's many tens of pages of very considered areas for the scheme, and I think it's positive for this development rather than setting out that this is a negative for the scheme, that it started off bigger and ended up as a smaller project.
Thank you. Okay, so before we move away entirely from policy 11, because I do want to look at policy 4 shortly, but can we consider just for a moment the parallel provisions of the LDP relating to wind energy? So just get that in front of me now. So, Mr. Bell, you've argued that LDP policies IN1 and IN2 are incompatible with NPF 4 policy 11 insofar as these policies don't specify the weight to be given to the benefits of the development. So my question is, given NPF 4 and the LDP stand together and ought to be read as a whole, is this an incompatibility? That's quite a powerful finding. It's quite a significant finding, and is NPF 4's instruction on weight to be given to the benefits contradicted by IN1 or IN2, or is this more of a kind of a policy layering point?
Sorry, I didn't catch your last.
Sorry, is it kind of like the sort of layering of policy where you have NPF 4, you have your LDP, you have your supplementary guidance, and you take those together to understand the direction of policy?
Yes, I think when you look at IN1, IN2, you've got the spatial framework reference, and clearly that's no longer applicable. It is the weight point, but I think the bigger issue I would say in terms of what I think is an incompatibility is policy NE2 that we'll come on to rather than IN1 and IN2. The criteria within them are pretty much the same as what we have in NPF 4, although we don't have that reference that we've just spent some time on about localised and design mitigation, and tourism is one of the gaps we'll maybe come on to in the policy as well.
Liz Bailey, any overarching views on this?
Yeah, I mean, I think I've gone into some detail in my hearing statement, and just obviously just ask you to look at those provisions. But yes, overall, I don't consider that the two documents are incompatible with one another. Sorry, I've just got a bit of feedback.
Yeah, so are you and Mr. Armstrong in the same room?
We are, yes.
It might be, might be because both microphones are on. Mr. Armstrong.
Sorry, I was just going to come back. That might be the reason why there is the feedback. But I suppose on a more general point in relation to compatibility with policy 11 and IN1 and IN2, this is clearly an argument that Mr. Bell has run, I think, in inquiries that I've been involved in on at least 3 occasions, and we've got the in relation to Dumfries and Galloway Council area, and we've got the 3 decisions: Sanker 2, Shepherd Rig, and Forside, and in all 3 occasions, Mr. Bell's argument in relation to incompatibility and IN1 and IN2 has been rejected by the reporters and by the Scottish ministers. So, sir, I'd submit that is obviously a factor to take into account in relation to consistency of decision making, that if an argument has been rejected 3 times, then there might be an expectation that it will be rejected a 4th time.
Thanks, Mr. Armstrong. Mr. Bell. You're muted, Mr. Bell.
Just to add that what I fully accept those previous decisions. What I say in my hearing statement is the incompatibility is insofar as the policies do not specify the weight to be attributed, and that is a difference. Whether it's an incompatibility or a difference, that is what I'm highlighting, and I would just maintain that position. That that's important to acknowledge. Thank you.
Ms. Bailey.
Thanks. Yeah, just obviously to just follow on from that point, that you are looking at the policies of the development plan in totality, so that includes both NPF4 and LDP together. So I don't see that there's any particular incompatibility in reading those policies together and coming to a different conclusion. I think when you read the LDP policies with MPF4 policy 11, you can clearly come to similar conclusions in terms of that balancing weight of the sort of the benefits of the scheme in relation to the impacts.
So, Mr. Bell, I see your hand up, but I'm not sure if it's still up or.
Yeah, sorry. It was just to say, I think a helpful approach, and I've heard before from a reporter, is if you have an issue you're dealing with and you run it through policy in the LDP and a policy in NPF4, and you get a different outcome, despite it being the same issue that you're seeking to address, then that would indicate an incompatibility. And we have guidance from the chief planner that an incompatibility is a conflict or a contradiction. And I think whilst IN1 and IN2, because of the balance that has to be struck, may not be evident in those policies, but I would say that in NE2, if you're just looking at policy NE2 and you run an appraisal of a development, you may well get a different outcome comparing NE2 against policy 4 of NPF4. Just putting aside the bigger balance in policy 11, which we do need to come to, and I think that might be a helpful approach.
Thanks, Mr. Bell. Yeah, so I will come back to NE2 very shortly, and we'll look at NPF4 policy 4 together with NE2. So I can reach my own view on whether that's an incompatibility or a difference. I think that's there is a distinction there between the two as to whether it's an incompatibility or a difference, and that's perhaps quite an important distinction from the council's perspective in terms of its ongoing use of policy. So, Mr. Bell, you mentioned then the tourism point and the fact that tourism isn't referenced in NPF4, certainly in NPF4 policy 11, in the context of energy, but policy IN2, I think it's IN2, does make reference to it. So I suppose my question is it legitimate? I appreciate that the sequence in terms of which document came first. It was clearly LDP, and then NPF4 came in later. But is it still appropriate for the LDP to kind of widen the specified considerations of policy 11 and bring tourism into the mix here? And in policy 11, do any adverse effects on tourism fall to be balanced under part C anyway in terms of maximising net economic impacts? Is it still implicit within that question? So I'll come to Mr. Bell and Ms. Bailey.
Yeah, I think as Ms. Bailey was saying earlier, NPF4 and the onshore wind statement came out pretty much the same time. Yeah. And we've covered this morning some of the references in the OWPS policy statement on tourism. And the government said, look, you can possibly get some discrete impacts, but generally not the rule. And there's much more scope for positive elements of a development such as access and recreation to be advanced in the future with schemes that may come forward. And I think certainly in the 20 years I've been looking at renewable energy developments, the tourism debate has come and gone, and I think the government's made it clear that through NPF4, it dropped it from one of the impacts to be addressed. So I'm not saying it's not a material matter. I think the onshore wind statement says there can be impacts. It depends on the receptor that may be in the area, but it's noticeable that it's now not a factor. But I think it's to some extent subsumed within the landscape and visual assessment as well. So it's also a matter that I'm seeing regularly being scoped out of EIA exercises. But it's not something I'm saying we need to dismiss. It's a material matter to take into account.
Okay.
Thank you. Yeah, I don't have anything really much further to add in addition to Mr. Bell's position. I agree with the points that he's making there, that it is a relevant consideration. And of course, there are differing views in terms of tourism, and yeah, I accept the points that are being made.
And we're not seeing the reference to tourism in IN2 as a incompatibility point with policy 11. Is that fair to say?
No, I don't think it is. Sorry, I'm just trying to find IN2 just before me. I mean, in IN2, it's under other impacts and considerations, and and clearly, in the terms of the council's objection on the scheme, it is primarily in relation to the landscape and visual impacts as they relate to IN2. So it's not specific to the tourism aspects of that. I don't consider that it is incompatible with policy 11 on that count. And as you say, I do think that the tourism aspects would be considered under the sort of the socio-economic impacts aspect of the policy.
Thank you. Dr. Lloyd.
Yes, I would just like to echo that. I think that there's two different issues here. One is whether it's included, and the other is whether it's positive. And I think that whether or not we have a debate about or an incompatibility about what is within scope, I think that the discussions that have taken place to this point would suggest or indicate quite clearly that the net impact is adverse. So where it's considered and what weight is given to it may be debated. The magnitude and direction is clearly significant and adverse. And I think as long as that's accepted, I think that would be a reasonable summary of the discussion at this point.
Thanks, Dr. Lloyd. Mr. Bell, is there anything you would like to comment on there before I move us on slightly?
Yeah, just to record, the applicant's position is not that it's agreed that the impact on tourism is significant and adverse. We covered that on Friday.
Yeah,
I just wanted to make that point. Thank you.
That's right. Thank you. Okay, so in terms of NPF4 policy 4, so that's natural places, we'll look at this policy first, and then we'll look at LDP policy NE2, which relates to regional scenic areas. So policy 4A says that where a development will have an unacceptable impact on the natural environment, will not be supported. So in one sense, that's obvious, because unacceptability can't be overcome if something's unacceptable. But I suppose acceptability overall is normally a balancing exercise, and I take that to be what this policy means. We've already talked about kind of relative weight. So does policy 4A indicate that regardless of the benefits of a scheme, certain effects on the natural environment cannot be outweighed? I suppose that's my starting point. It's just understanding this, I suppose, the strength of that policy 4 lever. Mr. Bell, could I have your reflections?
This was a statement that was in the former Scottish planning policy, and I take the view if something is deemed unacceptable, it cannot be outweighed.
Valerie?
Yes, I'd agree with that position.
In terms of Part D, policy 4, which applies to effects on landscape and local landscape designations. So I'm looking forensically at wording now. Does the or between 1 and 2 mean that significant adverse effects on the integrity of the RSA, if indeed that's found to be in existence, so are they accepted where the benefits of a development are of at least local importance. So is the or a get out clause? So it kind of almost it doesn't. It's not fatal to conclude that the integrity of an RSA is compromised if you apply part 2 under D that thinks about the scale of benefit. So I'll come to you first, Ms. Bailey, on this one, because I know that you have views on this, as I'm sure you do, Mr. Bell.
Yeah, so I mean, for me, the part 2 is an aspect which is triggered really where there is a view that there are significant adverse impacts on the integrity. So I think if there are no significant adverse impacts on the integrity of an RSA, then you would likely say that the application, the development, complies with that part of the policy. Where you do think that there are significant adverse impacts on the integrity or the special qualities, then you need to look at part 2, and that's where that balancing exercise comes in relation to any significant adverse effects on the area. So I think, as I'd noted in my statement, it certainly wasn't clear. I appreciate that Mr. Welsh and Mr. Bell have expanded on this in their evidence for the inquiry, but it certainly wasn't clear from the planning statement or the additional information that was provided to the council what the applicant's view was in terms of impacts on the integrity of the area. And I note the council landscape officer's position that she certainly had some serious concerns about the impacts on special quality. She didn't necessarily view that as having an overriding impact on the integrity. Mr. Wimble has, of course, reached his own professional view on that, and he considers that it does. And and taking into account the fact that the planning committee had serious concerns about the scale and nature of the application and the impacts on the regional scenic area, I think it must be assumed that the committee also did have concerns about the integrity of the regional scenic area. And so therefore, I think we are then looking at part 2 in that balancing exercise as to whether the significant effects are clearly outweighed by the social, economic, environmental benefits of at least local importance. And also just going back to the point that we made earlier in relation to policy 11 and the sort of the scale of maximising those net socio-economic impacts, etc. I've made the point that you're not just looking at it on the basis of, because it's a larger scheme, it's got larger benefits. You're looking at, has it maximised it in the context of the scale of the scheme that's being put forward.
Mr. Bell or Mr. Hardy, I'm taking your camera
like a lurking
as an indication.
exactly like a lurking presence when I turn my camera on. I was just sort of listening intently to that. Clearly, you heard all of the evidence last week in relation to parties' cases on impact on integrity. I don't want to go back over, or all of that, but I thought Bailey sort of indicated that. Thought she said that the applicant hadn't been entirely clear in relation to that. I mean, we've been absolutely crystal clear, in our submission in relation to that. There is no undermining of the integrity, and as we looked at in detail, that was the very considered view of Janet Swales. I'm not going to open it all up again. You've got all of that information, but that was dealt with squarely last week.
Thanks. Mr. Bell, in terms of that kind of wider question around the interaction between the two parts of this part of the policy, in terms of the integrity question and then kind of more than local benefits, and have your views on its application, please.
Yeah. As Mr. Hardy said, no undermining of integrity. Whether there's impact on some special qualities, again, Ms. Wales has set out a view on that. Just very briefly say, paragraph 313 of her response, that's electronic page 40, the scheme would detract from special qualities, but would not compromise them. So, if we take it, there's some some significant effects, if we're engaging the second part of the policy. So that's any adverse effects on the integrity. Now, it doesn't say in that second part or the special qualities. Now, that may be just a drafting error, but the test there against integrity is that any significant adverse effects are clearly outweighed. So I accept it does say clearly outweighed, not just outweighed, by benefits of at least local importance. So, I think if this was a 15 megawatt scheme or even a 22 megawatt scheme, major development, we might be having a debate about, is this just a benefits of local importance or not? Certainly not national. But we are dealing with national development. We've got a development that is, from a wind capacity, we talked about more than 8 times the minimum qualifying threshold. So is the position then that that's clearly outweighing? I would say it is. And we need to look at this policy first before we then go on to that wider balancing consideration that is in PF4 policy 11.
Thank you. Bailey.
Thank you. Yeah, I guess the difficulty I have with that position, just in terms of, and as I say, it's very much down to the interpretation of the decision maker about what you mean by clearly outweighed by social, environmental or economic benefits of at least local importance. But I guess, going back to the point that we've made earlier about, the concept of development in the right place, there is, and you could get to a theoretical position that the larger the scheme, the larger the benefits. Well, of course, it's going to clearly outweigh any impact on the environmental considerations and impact on the RSA. And that, to me, seems very much counter to the concept of development in the right place. And that's why I think that has to be looked at really carefully. And you can't just rely on the fact that because of the scale of the scheme as a national development and the amount of renewable energy it's going to generate and the amount of economic impact that's going to bring by virtue of its scale clearly outweighs those impacts on the integrity of the natural environments. And going back to the point that's been made earlier about, as I say, development in the right place and the importance that MPF4 does also place on protecting the special qualities of Scotland, protecting the special qualities of our natural environments, those do need to be given significant weight as well.
Mr. Bell. You're muted again, Mr. Bell.
Right, that's 5 times, I think.
Don't worry, I'm not counting now.
Sorry, I think the context needs to be taken into account. We've got NPF4 Policy 11 saying, look, it's policy of encouragement and facilitation in all areas outside national parks and national scenic areas. So that includes local landscape areas. We've also got this emphasis coming through on targets, and we looked at the onshore statement saying that taller turbines, more of them, this will change the landscape, was underlined. And if you look at how the government's approached certain policies, wild land has been relaxed, allows for renewed development to contribute to targets. And this is a particular policy change in relation to local landscape areas. One might argue to enable development more so than was before. Now, the policy doesn't say that, but from an interpretation as we are looking at today, the wording is expressly clear in my view that there's a balance to be struck, and the government gives us a clear threshold of at least local importance to clearly outweigh. And yes, there is a judgment of the decision maker as to, is that clearly outweighing any adverse effects?
Okay, thank you. I'm going to move us on slightly. Dr. Lloyd.
Yes, thank you. I listened very carefully, and again, as somewhat of an outsider, when one talks about local environmental benefits and assessing them, I just want to go back to the point that we have already discussed, the fact that the view here is of an export facility, the grid mix is of a UK mix rather than a Scottish mix. When you're actually building locally, there is no evidence here in the proposal of local environmental benefits. And I can't see how any can be argued. Whether there is a balancing decision to be taken on a UK-wide perspective about whether this is a sufficient loss on one hand to mitigate a potential benefit on the other is a different matter. But can we be clear that there are no local environmental benefits in this case, and at least be crystal clear on that point? Thank you.
I'm not sure that the applicant's going to agree with that position, Dr. Lloyd, but Mr. Bell, are you in a position to answer now, or Mr. Hardy?
Let Mr. Hardy first.
Say no, I haven't got. No, we don't. Of course, we don't agree with that, and the those benefits of set out in the information. There's lots of. I think we've got to be careful. I think Dr. Lloyd is very good at saying it is agreed that, or there is consensus that, and actually, there's just a general traverse that we're going to put in. Our case is that which is set out clearly. It's been done in writing. So even if we don't come back on everything, we don't agree. But that isn't agreed, as you appreciate.
Okay, thank you. I'm going to move us on, not very far though, because I want to look at NE2 as I indicated. So there looks to be broad agreement between the applicant and the council that its requirement for there to be a site-specific need for the development is incompatible with NPF 4 policy 4. So unless anybody tells me otherwise right now, I'm going to kind of disregard that aspect of the policy. So it's more a broader point, actually, so which has been picked up upon. So in the applicant's position statement, as far as I should be taking that into account, it says the council acted against the Scottish government's and its own policies. So, Mr. Bell, could you just say a little bit more on what was meant by that and how it acted against, how you consider the council has acted against policy, given that point around, well, there are judgments to make here, rather than it being kind of absolute. But anyway, I'll give you a chance to respond.
Yeah, no, there are a number of judgments to be made, but if there is an incompatibility, then the provisions of NPF 4 will prevail, given the amendments that have been made to the Planning Act 1997. And I think it comes down to, if the council is relying on NE2 and not NPF 4 policies, then if we look at the bit of the policy that it seems we can salvage, and this is another problem if you start to go into an old LDP policy and we say, well, we can't use this bit, we can't use that bit, and what are you left with? But the bit we are, it seems, left with is the first bullet point. Preamble to that says development may be supported where the council is satisfied that factors taken into account designating the area would not be significantly adversely affected. Now, there's no balancing mechanism there. And if the councillors took the view, well, look, there's significant adverse effects on the RSA, we don't need to support that development. Contrary to that policy, if you apply it in that way, there's a very different outcome to what you might get if you're applying it against NPF 4 policy 4, as we've just discussed. And that's where I think you could get the same inputs in terms of those two policies, but get a different output. And that, I think, is a conflict. And we know from Chief Planner's letter that could then be an incompatibility. So notwithstanding there might be other decisions, that's my professional view on how these policies compare. And I think that's a problem. And that's why I think policy 4 should prevail rather than relying upon any 2, which I think should only attract limited weight.
Thanks, Mr. Bell. Ms. Bailey, I'd like your kind of response to that, and also, I suppose, as far as you're able, kind of that your understanding of the balancing that's taken place by the council, and that I suppose that what should anything be read into the absence of MPF4 policies being referred to in its objection, because I suppose that affects. Okay, so how has this decision been taken?
Yeah, I mean, you'll have read the committee report. You'll see that it is a very comprehensive, detailed committee report which goes through all of the relevant policies. And then the case officer breaks it down into, if you like, key issues, and then provides a view in terms of whether the application is compliant or not with policies in relation to those key issues. So I think it's clear that when you look at policy NE2, that first part of it, that the factors that comprise the special qualities of the area are significantly adversely affected, and certainly that had come through in the landscape officer's response, notwithstanding that she had ultimately not recommended an objection to it. Having watched the committee meeting, and obviously the decision that's been made by the council is the committee's decision. You can't necessarily take into account absolutely everything that individual members say, because it's a collective decision. But certainly, it's clear to me that there was discussion about that balancing exercise to be undertaken in terms of looking at the landscape and the visual impact in relation to the wider benefits of the scheme. So I certainly don't view the council as having ignored that aspect. I do recognise that they have referred to policy NE2 and not specifically to policy 4 of MPF4 in the terms of their objection. I've set out in the hearing statement why I don't think that position is incompatible, and I think also having regard to the previous decisions that have come forward in the other cases that Mr. Armstrong mentioned earlier, they are working from a position that the LDP is not incompatible with MPF4 in relation to wind energy development, so they're looking at it on that basis. And sorry, if I could also just comment, and just there was a part of my statement where I just also confirmed that in looking at NE2, whilst yes, and absolutely agree that you would be not taking into account that second bullet point, because that part isn't does contradict what's said in policy 4. There are still, when you look at the policies and the plans as a whole, there are still ways and means to undertake that balancing exercise in the LDP, which is consistent with the balancing exercise in MPF4.
Okay, thank you. I don't think I need to ask anything more about NE2. I think I'm clear on what it says and what your respective positions are. I'm conscious of time too, so before I move away from this agenda item, so I don't, just so you're all clear, I don't intend to delve any deeper into either MPF4 or the LDP. So matters such as policy 3 and so on, they're important, and I'm going to have to consider them very carefully, but I don't need to discuss them today. Dr. Lloyd, I'm very mindful. So on page, I think it's page 29 in particular of your hearing statement, you've made reference to some MPF4 policies which others haven't cited in hearing statements. The council's referred to them in their committee report, or some of them anyway, in the original committee report. So if I could just touch on these in the order in which you've referred to them, so these don't get missed. So policy 20, so these are all MPF4 policies. Policy 25, community wealth building. Now, reading that policy, it looks to me that a prerequisite for applying Part A of policy 25 is a need for a wealth building strategy to be in place. I don't know if there is one. Ms. Bailey, do you know if there is one, or Mr. Armstrong, or indeed Mr. Bell, or anyone else, as to whether there is one?
Sorry, could you just repeat that part? I was just looking for that.
Yeah, so
Part of the
is
committee
there a community wealth building strategy adopted locally or wider by the council or some other body?
I'm not aware that they have one adopted. I would need to come back to you on that.
Mr. Armstrong?
So that's a matter that we can confirm in writing if you wish.
If there is one, I think I would like to be aware of it, and then I may ask for submissions on that point as far as policy 25 might then be engaged. But I won't try and go into that any further now. But in terms of part B of that policy, that supports community ownership and management. But my interpretation of it is it doesn't resist proposals where this isn't the case. But Dr. Lloyd, I'm conscious I'm kind of answering questions here potentially. I suppose there's a broader point there that you make about the kind of community aspects to this. So I'll give you the opportunity to, rather than me recharacterise what you're saying, I'll give you the opportunity to speak.
Thank you. This was really an attempt here to try and build a matrix between the sort of concerns that I've raised and the policy process that you're engaging in. So I think that these things are important to consider. We may open another discussion about how well they have been considered, but I think you will see, of course, from the previous week's exercises that these are significant concerns locally, and having them registered as such and assessed as such, I think would be very, very important. But I can't speak to how well the existing policy actually allows this to be considered and how well prior cases actually show how this has been done. And I think that the responses from Ms. Bailey and Mr. Bell suggest that this is an area that is somewhat out of the usual scope. And I'm a little bit surprised by that, but I don't have any prior history to base that on. So perhaps taking your theme forward about saying, can we get more written about this? Can we get a further submission on this? That I think would be a very positive way forward. Thank you.
Right, I mean that's very specific to the question of whether or not there's a wealth building strategy in place, because that affects whether or not I think that policy becomes engaged at all. So in terms of, well, perhaps I'll look to Mr. Bell and Ms. Bailey in terms of, have you got Dr. Lloyd's statement in front of you on page 29, and if you have that available, I'd like any reflections on the policy implications there which are referred to. So we have policy 23, health and safety, and there's the links back there to the best fire risk discussion that we had on Friday. There's policy 20, blue and green infrastructure. And there's policy 14, design quality in place, and looking at the kind of consultation engagement processes. I'll pause and just give you a chance to take stock of that, and then I'll come to you, Mr. Bell, if I may.
Thank you. I was just in the process of trying to find the statement, and I think I've got a note of policies, if I could just go through them fairly briefly. I think in terms of policy 25, community wealth building, the policy outcome is local economic development that focuses on community and place benefits. I think, it might be, for example, something like a local visitor centre or something like that was to be sited in the countryside, or so on, or within a settlement that is consistent with a local community wealth building strategy and a local economic priority to diversify, something like that. It's not principally directed at wind farm or renewable energy development management. And in terms of local supply chain and job creation, these are already points taken into account in NPF4 Policy 11. In terms of health and safety, it may be certain cases where that is engaged, not particularly in this case in relation to that specific policy. Policy 20, blue and green infrastructure, I wouldn't see that as being really particularly relevant here. And design quality in place, policy 14, I think probably more relevant for conventional built development and urban development rather than renewable energy projects, where policy 11 already provides for sufficient guidance on that. And again, you can look at all the decisions that have been issued by the ministers since NPF4 came into force, and I don't think there's any decision that references any of these policies. So I'm not saying to Mr. Lloyd that these matters are, not relevant. I think in terms of some of the points about broad design and siting, they have been considered in this case, but within the ambit of some of the other, we would say, more directly relevant policies.
Thanks, Mr. Bell. Yeah, I think so. The direct relevance is a key point there. Ms. Bailey, is there anything that you would like to add, or do you take a different view to Mr. Bell or indeed Dr. Lloyd?
Thank you. Sorry, I was just trying to get the right page of Dr. Lloyd's statement there, so just to make sure I've got the policies that he's referring to. Yeah, I've heard what Mr. Bell says. I don't take any particular difference, I don't think, in what he's saying there. I'd also highlight that in the Council's committee report, they did identify what the case officer considered to be the relevant policies, and that is in section 4, which I'm just trying to... So that did include the health and safety policy. Yeah. It did include the flood risk and water management. So I'm just trying to cross-reference this with Dr. Lloyd's reference. There was no reference to policy 25 on community wealth building. And yes, so I don't think that was really a particular issue that the council considered to be an absolutely relevant policy for this particular application. And I accept what Mr. Bell's saying in terms of some of these sorts of things are very much around trying to see whether there are opportunities for the local community to be involved with and have direct economic benefit from schemes such as this.
Great, thank you. Dr. Lloyd.
Yes, thank you. You'll see that at the end of each paragraph, I've tried to make this relevant to the current proceedings. So, for example, in terms of wealth building, this is about balancing, if you like, the fact that a scheme like this, because of constraint payments, will add to the cost of electricity to the wider Scottish population and the UK population, unless there are market changes made by Ed Miliband. So anyone here who is trying to look at the benefits economically that have been cited for the project has to bear that balance against the fact that any economic benefits go to the community are adding to the cost of provision of electricity to the wider population. And so this is a balancing act that I think is complicated. It's a wide area problem, and it's something that some people feel very seriously affects their willingness to engage in similar projects because the benefits are actually taken from someone else. In relation to point 3, the best, or rather, let's take point 4, the blue and green infrastructure. There has been no discussion at all about endocrine disrupting chemicals being released into a population that is proximate to these very large turbines. That, I think, is an issue. Now, it's a complicated issue. I've given quite a lot of material on that, trying to pick out the debate that's occurred across Europe, in the US, around these particular issues, and some of the difficulties that the regulatory authorities have, certainly between Europe and the US, in dealing with these. But you will see that this is a regulatory gap that is closing, that Europe has taken a far more stringent approach to endocrine disrupting chemicals, and that even the places that build turbine blades with full PPE and separate air filters have not been able to protect their own workers from being contaminated by these chemicals. So this is a real health risk to take seriously. But of course, the science isn't there to really assess how big a health risk it is. And so I'm not here to say that this is definitely going to appear or that this would directly have an impact on the population. It is simply the case that that is considered to be likely, that this chemical is already starting to permeate most of Europe, and that's why people should take it very, very seriously. But because it hasn't been given any thought to, it can't be assessed because even if you try to assess it, the evidence is still evolving. So from a reporter's point of view, it's a very difficult one to include, and I understand your difficulty there. But I'm raising it here simply to make sure that it is recognised that the planning frameworks do allow its consideration, and that I think it would be reasonable to at least say this is one of the known unknowns about this particular project. We can talk about, I don't know what scope we'll have to talk about the other ones, but I hope that the next agenda item will allow us to touch on some of these points.
I think it will, Dr. Lloyd. Yes. And there I want to kind of think about not only policy gaps, but I suppose other regulatory regimes which are relevant to some of these points as well. So it's not a case of them being completely irrelevant, but it's the scope to which the planning system concerns itself relative to other regulatory regimes that have overlap and oversight, or where those gaps exist completely. So let's come back to that. I don't want to deprive anybody of an opportunity to say anything that they want to in this session. From my perspective, I think I've got what I need under item 3. So I'll just pause and just make sure that you all feel the same, and you've had the opportunity to kind of convey what you wanted to.
Just one point from me, and that is, as I think you've just made clear, there is the need to refine some of the information or the issues that Dr. Lloyd has put forward, because of course this is a land use consenting inquiry. It is not a general look at all the potential issues and all the potential scientific theories and all of the things that an inquiring scientific mind may be interested in. It's about land use matters. Clearly, there's a threshold of materiality which needs to be surpassed, and in closing, we'll make our clear where we say that hasn't. But matters like the last one in relation to contamination, in my view, are clearly not land use considerations which would impact on a Section 36 decision.
Once we started, okay, I think that's a good point at which we should take a break. So I would say we will have an hour for lunch. So if we could be ready to recommence at 2:10, that would be good, please. So, and then we're moving on to that point, item 4, policy gaps and their implications, and then we'll look at the overall planning balance, and that will then be us coming to a close. So I think we're well on track in terms of what is anticipated for today. But anyway, I will see you again at 2:10. So again, please don't leave the call. Just mute yourself, turn your camera off, and I'll see you shortly. Okay, thank you. Afternoon, everyone. Welcome back. Mr. McClymont, can I check you're there?
Yes, I'm still breathing. Thank you very much.
I'm glad to hear it. Good. Okay.
Are you having a good day so far?
Very good day, thank you. I hope you are.
That's brilliant. Thank you very much.
Okay, so I've taken kind of stock of the agenda and my questions. I don't think we're going to be terribly long now, to be honest, in terms of this further discussion. On item 4, so thinking about kind of policy gaps, I suppose to try and kind of frame where I'm going with this, I suppose I'm interested in kind of exploring the extent to which something becomes engaged in the planning system or not. I've tried to kind of give thought to this, and I think there's perhaps kind of, it might be a bit crude and simplistic, but there might be kind of four tiers of kind of relevance. So there's one where there's a planning policy or guidance on a particular matter, and this directly engages that issue as relevant to kind of as a planning consideration. So second, there are matters where there's either no policy, or where there is policy, its fit with the issue is more indirect, but it's still a relevant material planning consideration. We've got issues or concerns which are undoubtedly kind of valid, but fall out with the remit and scope of land use planning, and may or may not be covered by other regulatory regimes. And there are matters or concerns for which there's perhaps no kind of evidential basis. There's still perceived or actual concerns, but there's no policy or regulation behind them, and whether that's in the planning system or elsewhere. So as I say, that's kind of slightly crude and simplistic, but it might help frame our discussion. We'll see. Now, we've touched on tourism already this morning. I think we kind of reached the view that, well, okay, tourism isn't, in terms of energy policy, it's not referenced in policy 11. The LDP still accommodates it. Obviously, there are less relevant policy in NPF 4 relating to tourism. So I think I'm kind of comfortable with kind of how that fits into this. I don't think I need to go into that. Now, we discussed the best fire risk on Friday. I don't know if there's anything more to say on that either. I'm content with where we got to. We got into quite some detail, actually, probably more detail than I expected to on Friday. So I think as far as I'm concerned, I'm satisfied with where that sits, unless anybody shouts now. Infrasound got mentioned on Friday, and I suppose I'm interested as to where, if I was to stick with those broad categorizations that I outlined, if they're reasonable, where infrasound sits. I heard your response, Mr. Hardy, on Friday, so I recognise that. I don't know if there's anything you want to add now.
Well, just a little bit. So, I mean, our submission, infrasound, low frequency noise can be a material consideration. So it was dealt with, so in terms of sufficiency of information, that was dealt with in the noise chapter of the original environmental impact assessment, and that's the principal place that we would take you to. So, I mean, there's no question that just dealing with audible wind turbine noise, so audible operational wind turbine noise, that's got the ability to cause annoyance, and and if it's close to housing, I mean, not here, but if turbines are close to housing, then that's got the potential to cause stress and sleep disturbance. But that is not related to infrasound. So infrasound occurs at orders of magnitude below the perception threshold. And as we say in the environmental impact assessment chapter, they're at levels that many other sounds in the environment which people are exposed to on a regular basis without any attributable effects to health. So yes, it is a known phenomenon. It is well understood. This is absolutely nothing new from turbines. and low frequency noise or infrasound is not something which would count against this scheme based on scientific evidence. So that would be our response. So I'm directing you to the evidential basis for that, which is in the EIA. The other thing, I think, Mr. Bell, there is a decision which we submitted. It was in response to some of the comments on Friday, I think, on Mr. Campbell as well. I think we put that in yesterday. That is a decision of the ministers which deals with infrasound, saying, look, that is not a matter of concern.
Does infrasound get referenced anywhere in policy or guidance?
It isn't in the, I mean, ETSU, obviously ETSU 97 is 1997, the IOA GPG 2013. They are not specifically mentioned. That having been said, all types of noise are looked at by the acoustician, so it's something which is, which is known. Point being is you can't hear it. I think that the impact would be ground-borne transmission, and the evidence is that it dissipates so quickly that it just is not a problem. So it's not. I think that the concern, if it was going to be raised, isn't one that you can hear by its very nature. Low frequency noise is not something that a human can detect. The question would be, even if you can't hear it, does that somehow have an effect on human health because of the vibrations in the ground, or the very, very low frequencies? And the answer to that is clearly not.
Thanks, Mr. Hardy. Dr. Lloyd, sorry, I saw your hand and then it did go again. But
yeah, no, I was partly to do with the earlier issue, just to flag that the BESS system has just been rejected because of fire safety concerns in a populated area. So that's a current case that's just been reported in the last couple of days that you may not be aware of, but I think is material to mention.
I'm
Mr. Hardy,
actually, yeah. So is that a Scottish decision?
No, it's a UK decision. It's on the BBC website, and it's probably in one of the highest read items. So if you have any trouble finding that, I'm happy to point you towards that. But interestingly enough,
I'm just if I may just interrupt, just conscious. I mean, if that is coming in as evidence, then I do think we need to be clear on that, about where it is, what it is. I will have something to say about it, no doubt, in closing submission. So just through you really to ask whether, we're going to, that needs to be identified. We need to look at the circumstances and so on.
Yeah, I was going to say, so in terms of, I mean, I can't go to the BBC website to get my own evidence, essentially. So if there is a case which you could direct us to, not necessarily now, but it might be something that we could pick up in writing and have exchanges on that, because the applicant at least would need the opportunity to be able to see that and to respond accordingly.
And the obvious point I would make, sir, is that if that is just rejected at council level, I mean, there's a number of those. That is absolutely, there's a lot of fear and a lot of sort of scaremongering. If it was obviously a appeal decision or Secretary of State decision, then I think that would have some added weight. But we'd like to look at it. So I'm just putting a marker down.
Yeah,
I can't say at the moment.
That's fine.
I'm happy to engage in that. I'd just like to pick up just as a way in. Let's just remember that the reason why we want bigger turbines is that the power output from a turbine is a square of the rotor diameter. So you make the diameter bigger, the power output goes up as a factor of a square. As you make them taller, the weight goes up as a factor of a cube. Okay, so there are lots of nonlinear relationships in turbine design, and really the point here is that there is an argument clearly for more efficient turbines as they get larger, but that's a nonlinear argument, and it is really important to recognize that nonlinear arguments apply equally to impacts and things like noise. So nonlinear arguments applying to infrasound, for example, are that the bigger you make a turbine, the more infrasound you generate because these things are physically larger. And just to go to Mr. Hardy's point, it doesn't dissipate quickly. Infrasound, as I make clear in my submission, is actually, because it's a very long wavelength, will actually travel very much further. And so it doesn't dissipate quickly. The higher frequencies will always dissipate more frequently because they're more energetic, they interact more with the environment around them. Low frequencies, and this is why we use long frequencies for subsea communications and so on. Submarines use it. It's because the longer wavelength means that they will travel longer, and that's a very, very clear scientific argument. It's not a matter of dispute. The problem with infrasounds, of course, is that it's infrasounds impact on structures that people live within that cause them to be re-expressed at frequencies they can hear. And that's a complicated issue because, of course, it isn't something that anyone who is saying they're looking at the turbine's generation of noise can say how that's going to impact someone who's living proximate to that particular turbine. And it's also the case that as you get nonlinear increases in energy extracted, you also increase the length of the interaction. And this is where, and again, in my submission, I've made clear it is quite possible for the increased turbulence that's created by very large turbines to impact other turbines that then re-express the infrasound that's carried by the turbulence. So there are second order things that are not being taken into account here. We simply don't have the evidence of onshore turbines at this scale to say anything at all about how bad this is going to be, but we have to accept if the nonlinear arguments are going to apply to the energy extracted, they should be expected to apply to the impacts. And it is not fair to simply have it both ways, where you say we get all these benefits, but of course the benefits are nonlinear and exponential, and the impacts are of course linear, right? We'll just use evidence from turbines that are 80 meters tall to argue that ones that are 250 meters tall will have just more of the same. But that doesn't apply, it's not scientific, and that's where the scientific evidence is at the moment. Would you like me to say more about this? Because, you know, I've made separate submissions, but yeah.
Sorry, okay. Yeah, sorry to speak over you. Thanks, Dr. Lloyd. Yeah, just pause there for a moment. Mr. Hardy, I could see you were in disagreement with
yes,
with that.
Number of points really. I've found the battery storage facility. So if that's going to come in, and this is why we do need to look at these things carefully. You know, we can't just raise them, reference them without more. So it's a scheme at Merton Way, Osbaldwick. It's in England. It's near York, and it was a committee refusal, but it's to do with the absence of a second means of access, which is a so-called breach. We disagree with it in a number of these cases, whether or not this is right or not, but the absence of a second point of access for the fire brigade. The argument being that if wind is going in different directions, then it needs to they need to have physical access. So whilst it's to do with fire, it is not to do, actually that refusal is not to do with chemical composition or so on. It's actually to do with breach of the draft fire chief guidance note, which are being revised, and that access point is going to be dealt with in early 2025. So I think that is actually quite helpful as an example of why we can't just, you know, pick something out without examining it a little bit more. We'll put that, if you want to have details of that, so that we can put it in. I don't know whether you're interested. Or not.
I think given the discussion's gone there for completeness, yep, it would be better for me to have sight of it.
Then that's fine. What we'll do is we'll be able to track down I suspect we can track down the officer report and potentially the decision notice.
Yeah,
rather than a BBC article. It'd be better for you, I think, to have the formal documents.
Thank you.
Second point is again, it's one of these sort of scientific. What I've noticed from what Dr. Lloyd has been saying is that there's a lot of, I'm a scientist. There's doubts here, and we don't quite have all the information. That's fine, but that isn't the way the planning system works necessarily. And it isn't right that in the way that benefits increase, in the way described, that harms do in the same way. So you do get absolutely more power generation, and yes, it may be that low frequency noise increases, but it doesn't increase in the same way. So the degree of harm doesn't expand at that same rate, and indeed the ability for that infrasound then to cause ill health. Because it seems to me that's what Dr. Lloyd is there's got to be a point to it, not just a pure scientific, well, there's something we don't quite understand. In land use terms, that would have to be an impact, it seems to me, on health and well-being. And the idea of a sort of generalized vibroacoustic disease, so you may be aware, but there's been a lady, Mariana Alves Pereira, who's been around wind farm inquiries 15 years arguing that there is no credible evidence that infrasound or LFN results in harmful impacts on human health. That is the state of the evidence. So the highest Mr. Lloyd can put it is that there's a sort of scientific interest there. Maybe he wants to follow that up, but the state of the evidence is there is no empirical evidence to justify a concern based on impacts of LFN on health.
Dr. Lloyd.
Thank you. I would just say that, remember that the point we got to on Friday was that the fire guidance was going to be to let it burn. So the issue of access is somewhat less important in the case where you're going to stand back anyway and let it burn, because you're not going to try and get the fire tenders in there. So there's an issue we can look at in there. I have to say that that in relation to my submission on the long distance effects, wind stealing, wind wakes, etc., that this was responded to using evidence that was very dated. So it's not, I think, appropriate to say that the latest scientific evidence supports Mr. Hardy's position, because that is not proven or stated in the evidence as submitted. I would also like to raise, since we are able to have this sort of discussion, the fact that wake losses and wind stealing have been recognised under the UK planning guidance and have led to conditions being imposed on a proposed wind farm. And I think it's worth that case being considered, because of course that wind farm actually includes turbines that are smaller than the ones that are being proposed for Scoop Hill, but are of the order of the offshore turbines, which are in the sort of 100 to 300 meter range. So there's things we can learn from turbines of this scale. And in this particular case, the wind was only blowing across from one wind farm to the other 5% of the time. That was equivalent to a 2% loss of output. And on a 90 megawatt wind farm, that was equivalent in 2022 peak electricity prices to an annual loss of £2 million per annum. These figures sometimes sound small, but remember, when things are operating 24/7 for 30 years, the overall impacts on economic impacts can be significant. And of course, if you're left with the economic impacts being degraded, but all of the costs, the carbon costs of the infrastructure being located in your carbon account, then of course this starts to make projects that might appear on counterfactuals that include coal and oil as positive, as in reality highly adverse, or at least neutral to adverse. And I think we're not at the point where we can say that the scientific evidence that's available to us today has been properly applied in this case. And I would say that there are things like wake losses, like bisphenol A, endocrine disrupting chemicals, the issue of infrasound and how it's expressed through this geology. Those are not well-made arguments on the basis of current academic thinking. Of course, there's lots of questions out there. We can't put this into a simple calculator and say this is going to be the outcome. The carbon calculator itself has been discredited and is being updated precisely because it is dated and limited in terms of how it describes the benefits that we expect to come from such schemes. But we do know that there are big questions. And then we have to ask ourselves, at what point do we say the precautionary principle should apply when the answers are simply not clear? And I would say that I agree with Mr. Hardy that there is a lot of scientific interest. But if you look at the quality work, then you can see that a pattern and concern has real weight and should be given weight in these considerations. Thank you.
Thanks, Dr. Lloyd.
Excuse me,
You've got to take. Sorry, was it Mr. McQuarrie?
Yes, I think from an outside point of view, may I suggest that this requires further investigation separately, the infrasound in particular, and electromagnetic radiation, for example, for aircraft. Thank you.
Thank you. Yeah, so I want to take care to not conflate these different issues as well, because we covered quite a lot of ground there. Mr. Hardy, you've got your hand up, so I'll let you come back now, and then I'll.
Well, no, just to make your point. Yeah.
No, sorry, go on. No, go on.
No, just you made almost my point for me. I hadn't even got on to kind of wind stealing, and we quickly diverted from LFN to something else. So I think there are three issues that I have seen, which I think we should keep distinct, and probably add to that a fourth, the sort of generalized scientific issues. But on fire, I think we've dealt with that. The final point I would make is that the reason for refusal was because of a perceived breach of that policy note. So the idea about, well, the current guidance being to let the battery unit burn out, there isn't any incompatibility there. It is actually what would happen, but that didn't stop the council from refusing consent on the basis of a breach of a policy note, which actually, is draft and is going to be updated. So that's the York scheme. In relation to LFN, there is a lot of evidence, and that is summarised and in the findings of the or in the text which is in the original environmental impact assessment report. There is no evidence to show a causal link between LFN from onshore wind turbines and human health, and that is our position, and we say that doesn't reach any threshold. In terms of weight, then, and wind stealing, we put in a written submission, so as you know, in relation to that matter 7, which is detailed, and this is, this again is a sort of interesting scientific kind of idea, but back in the real world isn't something which crosses the threshold of materiality. And the starting point is that wind is a natural resource. It's not a personal commodity, and it cannot therefore be stolen. The sort of impact would be potentially a commercial, operational impact, which would get sorted out between commercial operators. But the thing is here, it doesn't apply because there aren't any immediately adjoining wind farms, or indeed any wind farms within a 9-kilometre radius, and we've put in that plan. So wake and fatigue loading effects, they absolutely do affect immediately downwind turbines, but there just aren't any. So even if there is a concern, theoretically, that does not apply, and we say that is a commercial interest only. It's not something which bites on or engages with the consenting process. There are also substantial differences with the offshore turbines, given topography, the impact of ground roughness, and so on, which are set out in that note. So it's in that category of very interesting, not relevant for determination of this onshore consent. And then the fourth point was that other basket then of chemicals in the manufacturing plants and all those sorts of things. They are in the category of, they may be concerns, but there's no evidential basis. You can't do anything with those in our submission in terms of the onshore consenting process. That would be a matter for Dr. Lloyd if he wants to take that up with the health and safety executive, for instance, for exposing manufacturers in a plant to certain chemicals. That's something he could do, but it is not a land use matter that you can respectfully take into account.
Thanks, Mr. Hardy. So, in terms of the wind stealing, I use the term loosely, so because I take your point around it can't be
Who owns
really
it?
can't be stolen.
Yeah.
The so looking at your Matter 7 response, you pointed me to Scottish Government onshore wind turbines planning guidance for 2014, and that's the essentially looking at kind of separation distances internally for the scheme. So essentially that's in the interest, that's kind of good practice in terms of maximising efficiency. Is that correct?
Absolutely. If you're going to have turbine, because of course there are undoubtedly wake and fatigue loading effects. If you put turbines immediately behind, they aren't going to be as efficient. So the idea is to have a spacing format which allows maximum efficiency in terms of use of land, but also maximising generational benefits. But they are, as you've seen, they're around 3 to 4 rotor diameters between turbines, and we're 9 kilometres. I mean, it's just a completely different order of magnitude.
Thanks, Lloyd.
I would, as I think you did just there, point out that you were talking about intra-farm or inside the farm optimization, where of course you seek to extract maximum energy from the wind front as it passes through. I can tell you that there is no meaningful modeling of wake impacts on other farms. And whilst you talk about a distance, remember that we're talking about a wake that is measured at the scale of turbine that you're installing on top of the hill of 100 kilometers. So I took in my paper 50 kilometers as a conservative distance over which an impact might be felt. The fact that it has been quantified in the case just in Wales, with the 2 wind farms that have been in dispute last year, has been quantified by both parties. It is not just an economic or commercial issue, as you argue. In fact, in the submissions, I quote, "Wake loss is therefore a matter which requires to be considered by the examination. It is not simply a commercial issue between the applicant and the other wind farm operator." In fact, they were very careful in that determination to make the point that relying on an overly legalistic interpretation of policy would give rise to nonsensical results is a really present concern, because if we allow a narrow interpretation of guidelines to rule things out of scope or either unknown, then of course we end up with an optimization that is focused purely on economic extraction in one location, rather than thinking about what is economic and ecologically appropriate for the country as a whole. And my concerns, you might recall when I was talking about infrasound, I didn't actually mention the health impacts directly. That was you. I was talking about how infrasound travels over long distances and the relevance of that to noise generation, which of course goes to the SDL Muir case, because that is a transmission mechanism that isn't considered in your mitigation scheme at present, and yet I think is one that is material over these kinds of distances. Yeah, so I'm sorry, I'm broadening the scope, but as I say, it is a case under the current planning guidance in England that has recognised wake loss, wind stealing, wind theft as being a matter that isn't just a commercial matter between those 2 parties, because, as Mr. Hardy says, no one owns the wind. That's not my concern. My concern is that if we are going to build wind farms, we make sure that wind farms are extracting this in a way that is sustainable, that it isn't competitive with these existing investments, because we already bear the carbon cost of those investments, and we must make sure that their carbon payback calculations are respected. And their carbon payback calculations are predicated on measuring, extracting wind that they measured. Simply building one in front of that completely changes the calculations for everything that's downstream. And the point that comes very clearly from this case, that a 2% loss of wind energy, even with a 90 megawatt facility, can be measured in annual losses of millions. So if you're just looking at this economically and you don't think about the environment at all, you can see that this is a significant case. If you multiply that across every wind farm, every 80 to 120, 130 meter wind farm that is in the shadow of something that is on the top of a hill and is 250 meters into the sky, with the larger rotors than anyone else has, then you can start to see that's a major impact on the wind flow over this particular part of the world.
So just one final comment on that, if I may, and then I think I can leave it there. I can help with what Dr. Lloyd's got to say, because my firm is dealing with one of those the offshore schemes. We're dealing with Morecambe generation. So again, we've got to be a bit careful, because Mr. Lloyd was suggesting that the scheme, or sorry, the English system had picked that up. Those three schemes are in front of the examiners. There are no decisions. And the developers, so the Morecambe offshore developers, simply just don't accept that is an effect which should be considered. So the way Dr. Lloyd has set that out, if you didn't know any different, would be, well, there is precedent and somebody's made a decision. An argument has been made, but it's simply just not accepted. Moreover, those impacts that happen offshore in those particular circumstances are not relevant to the Scoop onshore wind farm that we've got here. And I think it is worth just saying that it's 9 kilometres to the nearest wind farm. But of course, if you're going to have the sort of losses that which are talked about by Dr. Lloyd, I think it's 28 kilometres to the nearest downwind turbine. And at those distances, the points that are made are just not relevant.
I'm going to move us on in just a moment. In terms of that, if wind energy is being lost kind of downwind, if that argument's accepted, do we have any examples of decisions which have or cases where other wind farm developers or operators have objected to a separate wind farm proposal on the basis of essentially lost or potential loss of energy generation by their wind farm? I recognise, Dr. Lloyd, you said there it's not just a commercial consideration, this, but of course, if you're producing less electricity, it's not in the interests commercially or in terms of carbon savings. So they go kind of hand in hand in that sense. But I just want to get does anybody have any awareness where this has become a issue?
Yeah, I do. So no decisions. This is not a consideration which is exercised decision makers for very sound reasons, in my view. I am aware over the years where, as with all sorts of commercial jockeying, there are people that seek to gain commercial advantage by saying, you've done this, or you've taken you've impacted in relation to Wake by having an extension built close by, or so on. But they're just dealt with and have been dealt with on a commercial basis. There aren't many of them, but I'm aware of them. It's a little bit like I've dealt with solar farms where you put a barn up or a large building and there's shading, and actually there's then a question of, you've stolen my sun, and then there are arguments about, do you need permission to allow somebody to put their barn up in the to create a shadow? So they're commercial commercial agreements, if in the rare circumstances they're needed. They don't, in my view, go to consenting, and I haven't heard anything from Dr. Lloyd which would engage the decision on consenting. The only thing I can think of is, as the assessment of benefits, so generational benefits and CO2 savings, being accurately estimated, and therefore the decision, the planning balance, has that been struck correctly? Because of course, once the downwind farm has been built, it's built. Whether or not it's acting as efficiently, that's a sort of commercial matter. But it would have to be, is there an upstream or an upwind wind farm which is somehow not being taken into account? Here at Scoop, there simply isn't. So it just is. It's not an issue which goes anywhere.
I would like to move us on in a moment. Dr. Lloyd, I'm happy for you to just give us a further comment on that, and then I'll move us on.
Yeah, it's not the wind farm I think you referred to. It's Awel y Môr, and it's Real Flats wind farm who raised the concern. And I think you raise a really interesting case about talking about what is a downstream wind farm. You understand that we have what's called a wind rose, which shows that wind has a preferred direction. Simply drawing a line through the predominant wind flow direction doesn't define upstream or downstream, except on those occasions when that wind flows in that direction. In the case of Real Flats, they are south of the proposed development. They are outside what you would describe as downstream. Wind only creates a problem for them in 5% of the 5% of the different wind circumstances that apply. That 5% is enough to reduce overall efficiency by 2%, and that 2% equates at 22 peak prices to over £2 million per annum. So, and that's only on a 90 megawatt scale. So these can be dismissed if you draw a straight line through a wind rose. They can be dismissed if you try to argue that this is too far away. But remember, these are quarter-kilometre turbines with wakes that have been measured offshore at 100 kilometres. Onshore, we would expect those to have some ground effect. But the higher you go and the bigger you get, the less the ground actually has an impact. And that's one of the reasons why you build them tall, because the wind flowing at higher levels is actually much more like the offshore wind because it's less affected by the onshore relief. So again, it's a scaling problem. We're going to the realm of offshore wind turbines. The empirical evidence points us to a concern around this. It has been recognised, and I'm encouraged by Mr. Hardy's recognition. This does come up in conversation quite a lot, but I think it goes to more than a commercial decision, because at the sort of densities we're now talking about of wind turbines certainly in the Moffat area, the potential adverse impacts from wake effects clearly gets larger. And if you're the largest turbines in town, you're going to cast the biggest shadow. In a solar sense, you're certainly going to cast a big wake loss for other people that previously didn't experience it and have calculated all of their economic and environmental benefits on the basis of that not being there. So you have to integrate the impact on them when you argue that you're having an environmental benefit. So that environmental benefit argument isn't made unless the downstream impacts are actually included. And that's really the point that I'm trying to make, that whilst there's an economic return to Scoop Hills operators, there is an economic disbenefit for other operators, and there is a net environmental impact that could be adverse. We simply don't know because nobody is trying to calculate it.
Thanks, Dr. Lloyd. I've understood the point. I'm pleased to say I don't need to try and get you to reach consensus today in this meeting. So I've understood both sides of the argument, and I'm satisfied I've got what I need for my purposes. So I'll move us on. Now, before I move away from item 4, can I check with you all, is there anything else that you think falls under this category that we haven't captured already? Okay, so I'm going to move us on then to agenda item 5. Now, I attend this item really to be a summing up of your positions, really. So it's a opportunity to reflect upon our discussions so far and pulling together the various aspects of policy. So that thinking about, I suppose, the in principle support, which we looked at first this morning, then matters of relative weight, and what you consider the decision ultimately turns on. So with that in mind, those points in mind, I'd perhaps like to start with Ms. Bailey. I'll put you on the spot first, but please do take a few moments if you wish. I'll then ask Dr. Lloyd and Mr. McClyman if you have anything to add, and then I'll end with Mr. Bell to bring it together. So whenever you're ready, Ms. Bailey. Thank you.
Okay, thank you. So I think just first of all, in terms of identifying what are the key provisions that are part of this balanced exercise, Obviously, I'm coming from a perspective as a planner, as is the council, as a local planning authority. So we do place a lot of reliance on the provisions of the development plan, which incorporates NPF4, which incorporates the local development plan 2 and the adopted supplementary guidance. And certainly all of those components are an important part of the development plan. I've also mentioned in my statement and also today that obviously the provisions of NPF4 in particular do take into account that wider energy policy position in terms of the latest policy drivers that are coming through, for example, in the onshore wind planning statement. So those are all certainly factors that I think are part of that balancing consideration. In broad terms, I view it as a balance between the benefits of the scheme in terms of the renewable energy generation, in terms of the socio-economic benefits versus the impacts of the scheme. And I think, as I say, and I've mentioned a few times today, I know about that driver for development in the right place. And I think that's a key component that needs to be given quite significant weight, particularly given that although wind farms are effectively usually for a temporary period, this is for a 40 odd year period, and NPF4 does require, when you're looking at sites for wind farms, that they are suitable in perpetuity. So potentially it could be for much longer than 40 years. So again, having consideration to the wider impacts, that needs to be a clear part of the consideration. I'd say, the council absolutely recognises that there is, in principle, support for renewable energy. It is identified as a national development in NPF4. Have commented, however, on the fact that although it's a national development in principle, that does not automatically mean that it is consentable in any location across Scotland. And I have highlighted some concerns with the fact that I think you need to take a considered approach in terms of looking at developments that are larger in scale, and how do you view that balance where it's quite clearly got more generation benefits, it's got more socioeconomic benefits by way of its large scale. You need to balance that against what are the impacts that are being experienced in the area where the wind farm is going to be sited. Obviously, the council has taken a decision that it does have significant concerns in relation to the landscape and visual impacts, and those include on visions of the regional scenic area. Those include on the core path and if you like, the recreational experience that people will have as they're travelling through the area. And they don't necessarily, I've come to view that I don't necessarily think they think that is localised. We also, just in terms of looking at the council's supplementary guidance, yes, absolutely, it does identify some scope for very large turbines within the southern uplands with forest unit, and particularly Eskdale Muir. But certainly it's clear to me on reading that document and on reading the emerging landscape sensitivity study that they view that more in terms of the core of that area rather than on the periphery and overlapping into other areas. So I do think that is something that requires due consideration. Perhaps really just to conclude, I think just to remind you of the final paragraph that's in my hearing statement, 6.1.6, where I state that obviously in its role as a statutory consultee as the local planning authority, it is relevant and appropriate for the planning authority to focus its response on the development plan. The local development plan too is an important part of that statutory development plan and should be read in conjunction with NPF4. We've set out why those provisions are not incompatible, although I have clarified, and I do clarify in my statement, that in terms of the provisions of the LDP2 on the spatial framework and the provisions in terms of that second component of policy in NE2, I don't view those as directly compatible with NPF4. But I think when you look at the totality of the policies together, you can come to a position where it really is more a scale of weight and balance, and you can read those policies together. And really, the final part of that paragraph is just to say that, in terms of the views of the local planning authority, which is the area where the burden of those effects will be experienced, it is suggested that those are given due weight, particularly given the wider intention, as I say, is for development in the right place.
Thank you, Ms. Bailey. That was very comprehensive, considering I just put you on the spot like that. So thank you. Dr. Lloyd, is there anything you would like to add?
You can hear me. You can hear me now. Presuming that this will be the last time I speak today. Is that correct?
It will be, yes.
Well, then the first thing I must do is to thank you for all your efforts on this, and to thank everyone else here for very, very interesting presentations. I have actually enjoyed listening to all the positions, and I've learned a lot about the due process. So I'd thank you for that. And I think as anyone involved in the community would say the same, that the opportunity to speak has at least allowed those concerns to be raised in, I think, a very constructive manner. I think I would like to just go back to the fact that this is an export facility on an industrial scale that reflects a belief that 2/3 of the target for the whole of UK onshore wind should come from Scotland without any future competition from the rest of the UK, particularly England. And it assumes the carbon benefits in 2027, in this case, will come from fossil fuel substitution or massive growth in consumption of electricity, despite lower consumption of electricity today than at any point since the 1970s, for a population that has grown by 22%. Accordingly, I think joined up thinking is really, really important in terms of linking infrastructure to jobs and a future economy. I think we need to be very careful here that attempts to rule considerations out of scope, irrelevant, or offset by benefits that will be experienced in distant places potentially, if not allowed. Otherwise, we'll end up with projects that have no net environmental or economic benefit within Scotland. And I've already raised my interest around similar schemes in terms of renewable energy and making sure they really do lead to high-value employment. The only local employment, and that employment had to be local, by the way, and everything I talked about in terms of my own interests is about local employment. It's about bringing those jobs in. The only jobs we've heard about locally today were quoted as fencing and track management. And both of those jobs already exist, as Mr. Warren pointed out. Those are being sustained by these kinds of activity, but they're not being created by these kinds of activity. And I think that's the problem here, is that we can see and sense the difficulties and impacts that Ms. Bailey has really articulated very well, and incredibly articulately, given the limited amount of time to prepare. We can see those, we can sense those, we can worry about those, and that does a certain amount of harm for those people living in the area, real harm, because the psychological impact is today. But we can't really see those benefits. And if we tie those to economic disbenefits, or the ones we've already invested in and already been part of as a community approving, then everything we've contributed is being taken away. We're getting those impacts today that are seen as adverse and negative, and we're not going to be part of the benefits that accrue from any substitution impact, because this is essentially being exported. So I think that there's a real difficulty here at core. I have tried to show how this particular place, because of the high density of existing infrastructure, the high contribution this area has already made to the generation of renewable energy, would actually be damaged over a wider area by this imposition, even though absolute levels would go up. The efficiency of extraction would certainly go down. We don't know how by much, but it would be an impact. And that would also raise the operational costs of maintaining downstream turbines that are subject to more turbulence. So there's a lot that happens to other people's balance sheets, both economic and environmental. And I would like to see that debate stimulated by this hearing, even though this hearing may not be able to take all of that into account. So again, I thank you for the opportunity. I thank everyone else for being here. And I look forward to listening to the rest of the sessions that you have planned. Thank you.
Thank you very much, Dr. Lloyd. Mr. McClymont, is there anything that you would like to say or add at this point?
I would like to be very brief, Mr. Warren. I've tried to get it down to about 2 words, and the 2 words I've chosen for further debate, please, if you don't mind, with your permission, is operational constraints should the consent be given. Now, operational constraints are already an issue in Shetland with the operator there. And for example, I think this is, you don't use it as evidence, but hearsay is suggested that in August, Scottish and Southern Energy were paid in, I think, August, £2 million alone, not to generate electricity. So getting back to what really I want to say is would like to see further discussion on operational constraints.
Thanks, Mr. McClellan. Yeah, so it's something that we very briefly touched upon, kind of the constraints payments that are made, something that I'm aware of as an issue. Perhaps we'll open it up now on that particular point, but Mr. Bell, you may or may not touch upon that in your summing up. I'll leave that to you. Thank you.
And may I wish you all the best, and may I wish you all the best for you, your family and friends in the future. Thank you very much.
Many thanks, Mr. McClellan. That's kind, and likewise. Thank you. Mr. Bell.
Thank you. I'll be brief. I think we've covered energy policy, and there's a real urgency to onshore wind deployment. It's very strongly in the public interest, and key word we went to in the conclusion of the onshore wind statement was mission critical to targets. We've examined the development plan, the most recent element, NPF4, to which most weight should be given in this case. And in terms of the spatial and locational guidance that it gives us, together with the supplementary guidance that the Council has prepared, it points and supports to the location in which the development is located. There's been a very thorough examination of the more detailed development management considerations, in particular landscape. And I would say Dumfries and Galloway sets a high bar for that. They have a very experienced landscape architect, and there is no objection. And in fact, there's clear reasoning why the development should be supported in the Council's official officers' documentation. So I don't propose to say much more, apart from that all of that, in my view, points to this being the right place. And subject to that development management detailed consideration, it is, we consider, the right development. And the benefits that it would give rise to are very substantial. And we've covered those today. Thank you.
Thank you, Mr. Bell.
Also, the final point then, in terms of Mr. McClimate's point, I think the matter of constraint payments is certainly a matter the Scottish Government is aware of, but it's not an issue that is given weight in decision making. I think one of the sort of remedies for that, not only is it the wider grid reinforcement that is going ahead through different application processes at the present time, but it's also the role of battery storage. And the government's made it clear that in order to alleviate and address the issues of intermittency and constraining off developments that do result in these payments that have been mentioned, then battery storage has an important role to store and deliver energy when the grid can't cope, and then to discharge it at times when it is needed. And NPF4 Policy 11 also tells us in the second last paragraph that grid capacity should not constrain renewable energy development. So I think that's a relevant point. Thank you.
Thanks, Mr. Bell. Okay. Right, I think that brings us to the end of today's session. So I'd like to thank you all for participating today. I found it a very helpful discussion. It's I've taken quite a lot away from today in terms of what will feed into my own reasoning and conclusions, and ultimately my recommendation to ministers. Tomorrow we have the final hearing session, which we've currently got scheduled at least, which is on conditions. So I will see some of you then, and that's at 10 o'clock again, so a second virtual session at 10. Otherwise, well, that's all for now, essentially. There's not much more to say at this point, other than thanks again for your time, and I will see some of you tomorrow. Mr. Armstrong, I see your hand up.
Yes, so there is one matter, if I could raise it
Certainly,
now, and it's maybe something you want to consider overnight and discuss tomorrow, but I raise it because most of the principal parties are represented today. It's been brought to my attention that due to the holiday season, there is an issue in relation to sign-off of what will be my closing submission by the council on the 6th of January. And as a result of that, I request that could that date be moved to the 10th of January in order to allow appropriate sign-off from the relevant council officials and others. Obviously, that would mean Mr. Hardy shouldn't lose out as a result of that, and I would suggest that there would then be a sort of further week, or I think it was a week between my submission coming in and Mr. Hardy's submission coming in, and that would extend the time for Mr. Hardy's submission to I think the 17th of January. But I've been informed today of that issue, and that's why I raise it now at the first opportunity.
Thanks for highlighting it, Mr. Armstrong. So in terms of that sign-off process, is there a particular committee meeting or something which you're working to, or is it simply when people are back in the office after Christmas?
It's when people are back in the office after Christmas, and the appropriate people.
Mr. Hardy, you don't need to respond now, but if you have a response, you're welcome to give it.
Well, absolutely, got no problem at all. That's everybody's got a right to have their annual leave and enjoy Christmas. So, sake of a few days, matters not. So, with my Christmas best wishes, Mr. Armstrong.
And I'm assuming, Mr. Hardy, you would be looking to have the closing subs deadline for yourself to be extended accordingly.
I would always welcome that Christmas goodwill to be reciprocated. So yes, that's Mr. Armstrong's gift to me.
Okay, so what I will do on that basis is I'll agree to that, but what I'll do is just to be fair to all parties, I'll extend that first closing submissions deadline for all parties to the 13th of January. It was the 13th, wasn't it, Mr. Armstrong? You said, was it the 13th? Let me double check.
It was the 10th. It was the 10th.
It was the 10th. Right, we'll go with the 10th. Yeah, sorry, I've got too many scribbles all over my diary now. Okay, yeah, so we'll go for the 10th. So what I'll do is I'll confirm to all parties that change in date, just so they're all aware. Okay, unless there's anything else, I'll bring us to a close today. Okay, I'll see some of you tomorrow. Thank you very much again. Take care.
Thank you. Cheers.